2023. And of course, we are streaming live on our YouTube channel. Please do may help us trend. The hashtag is hashtag ACLEP. That's the first one. Hashtag ACLEP. The second hashtag is Competition Conference 23. That is hashtag Competition Conference 23. I have a minor request, and this is from the photographers, especially for the people that are sitting in the middle section. They've requested that we please move inward towards the middle, just for aesthetics and so that our pictures look good. So if we could please move inward, this side looks a lot better, and perhaps if we can ask people sitting in that third row to please come a bit forward. We'd really, really appreciate that. Thank you very much. I'm going to hand over to Ufense while my lovely crowd indulges me. Thanks.
Thanks, Karabo. I have the very big task of introducing our very first session for the day. And as I was preparing for today, I asked myself, what is it exactly that I should say? And the biggest motivation for that is that my kid's livelihood depends on what I'm about to say next. So I had to choose my words very carefully. So to sing for my supper, as it were, and hopefully get a bonus after saying all the nice things that I'm about to say, wink, wink, perhaps I should begin by saying this, that I'd like to say a few words, not because the next person that's gonna grace us with their presence is the chairperson of the tribunal, but I think importantly because she has indeed made history as the first female and black chairperson of the competition tribunal. And I thought that was important for me to start with that, because after having celebrated Women's Month not so long ago, these kind of things need to be celebrated, not just on Women's Month, but on every single day of our lives, because we do know that we have not had a very fortunate past when it comes to how our women have progressed in the country. So for those who do not know, Ms. Mondo Mazwai is the chairperson of the competition tribunal, and she boasts 23 years, if not 24 years of competition law experience. Now, before I ask, in fact, perhaps I should do this. I'll ask her to join us on stage in a language that speaks to her heart, and I'll say this, Montele di Pilaruna, ke kopara o tle mo stage.
Good morning. Good morning and warm greetings to all our guests and colleagues. It is a pleasure to open this morning session with a view from the tribunal, which is what I have been asked to speak about. It is also an honor and a privilege to share this platform with my former boss, the Judge President of the Competition Appeal Court, Norman Manoyam, who taught me everything I know. So you can blame him for anything that goes wrong at the tribunal. What I thought I would do is to give some remarks on the tribunal's work in line with the theme of this year's conference, which is towards competitive markets, transformation, and deconcentration. I've been allocated 45 minutes. However, I'm a little under the weather with a crackling voice from the flu. So I hope the voice will cooperate for half an hour at least. I wish to start by saying context matters. What is the context in which we are today in South Africa and the world. John Maynard Keynes, arguably one of the most influential economists of the 20th century, once said, "The political problem of humankind is to combine three things: economic efficiency, social justice, and individual liberty." In his 1930 essay titled "Economic Possibilities for Our Grandchildren," he argued that the economic problem is not a permanent problem of mankind. It can be solved. South Africa's economic problem remains growing inequality, unemployment, and poverty. Added to this challenge, South Africans and businesses in South Africa are grappling with several pressures at the same time, from an ever-rising high cost of living to an electricity and energy crisis, climate change, and an ongoing technology revolution that is disrupting existing markets and creating new ones. One might ask, what does competition law and policy have to do with this? I would like to posit my remarks on several important edicts that underpin our thinking as the tribunal as we adjudicate to promote competitive and inclusive markets. The first is the Constitution of the Republic of South Africa. The second is the Competition Act. And the third, a little further away, removed from home, but relevant in the context of a global economy, are the United Nations 2030 Sustainable Development Goals. One might again ask, what does competition law have to do with this? And I will explain. We have already heard and held debates about the Constitutional Court's Mediclinic judgment 2 or 3 conferences ago, including just yesterday. We often hear cited the Constitutional Court's decision, which requires us to take a transformative, constitutional, and context-sensitive approach to our determination of competition issues, and not to let legal sophistry undo what the Competition Act seeks to do. This is not to say that competition principles are abandoned. Competition law is economics law, and therefore solving a market power problem sometimes requires something akin to piercing the corporate veil and digging a little deeper through our inquisitorial powers to get to the crux of the matter, and not to hide behind sophisticated legal and technical points. We've had a practical application of this in the Constitution and in the application of the Constitution and the Competition Act by the Tribunal and the Competition Appeal Court. I'd like to offer a third and additional prism in the context of a globalized world, which in my view aligns with the applicable local competition law and the Constitution of South Africa. And as I mentioned earlier, it's the 2030 UN Sustainable Development Goals. South Africa is a signatory to these 17 goals. I do so because we often are confronted by debates about whether our act or the way in which it is applied transcends the role of what competition authorities ought to be doing. One school of thought is the "it's not my problem" school of thought. Efficiency is all competition law should concern itself with. Because sustainable development goals are about equality and not efficiency, they're irrelevant to competition law and are not a competition problem. The second school of thought is that open markets and access to markets are important tools for efficiency, inclusion, opportunity, mobility, and economic well-being. The design of our Competition Act follows this school of thought. In 2019, the Competition Act was amended. The amendments are intended to maintain the basic architecture of the Competition Act while strengthening certain provisions of the Act to align them with the stated purpose of transformation and addressing concentrated markets. Professor Eleanor Fox reminds us that markets and access to markets stand side by side with food, health, shelter, education, environment, infrastructure, and institutions as critical tools to combat the world's greatest economic deprivations. Making markets work for people without power is an inherent sustainable development goal. As you know, our work as the tribunal spans two broad areas: mergers and acquisitions and prohibited practices. These two are our raison d'être, our reason for existence. Starting with mergers, we hear and decide mergers in order to prevent those that substantially prevent or lessen competition and or have negative effects on the public interest. In practice, we conduct a complete competition assessment, which includes balancing efficiencies and first and separately. The competition analysis is then followed by a public interest analysis. This separates the requirements for a competition analysis from what is required for a public interest analysis and makes it possible for the tribunal to strike a balance in its assessment. The tribunal also has to find the right balance between competing public interest elements listed in Section 12A3 of the Act in and of themselves. As an adjudicative body, we have to assess all these factors and weigh them against each other and take a holistic view, and the ultimate outcome is the net effects of the merger on both the competition and public interest issues. One observation is the public interest issues are often not adequately considered by merger parties. Take, for example, employment, a long-standing public interest issue. Very often, employment effects are not taken into account timeously and come as an afterthought. We do not see this in due diligence documents or board documents. Sometimes even up to the tribunal hearing stage, the impact on employment is not clear, and we have to ask parties to go back in order to do a proper assessment of employment effects. The same goes for other public interest factors. By way of example, in the Epirox merger, there was no substantial prevention or lessening of competition, and therefore no competition concern arose. However, there was a significant reduction in ownership by historically disadvantaged persons from an effective approximately 98% to 28% shareholding. An ESOP was proposed as a condition, and the question we had was whether the ESOP was enough to justify the merger from a public interest perspective, given the significant reduction in HDP shareholding. It turned out, only on probing during the hearing, that there were other positive public interest effects listed in Section 12A3 that would be brought about by the merger, including the impact on an industrial sector and the ability of national firms to compete in international markets. The acquiring firm, through its international links, would bring its technology and R&D, which would benefit local manufacturing. It would also open up access to the local firm to international markets to sell its products internationally. The measure was ultimately approved with conditions relating to the establishment of an ESOP, a moratorium on employment, or on retrenchments rather, and funding for skills, enterprise, and supplier development initiatives. The point is, these public interest factors were raised belatedly, despite the negative impact on the public interest raised by the merger, and this denies the Commission the opportunity to investigate these claimed public interest issues if they come at the door of the tribunal. Parties are therefore encouraged to address public interest factors upfront with as much vigor as the competition effects, as this makes for a better assessment of the net effects of the merger on both competition and public interest. And it saves time for all concerned. In the Heineken and Distell merger, we approved the merger subject to various conditions, including those addressing certain human rights violations. We imposed conditions to address concerns regarding increased concentration. These conditions require Heineken to divest of its local Strongbow brand and business to a licensee having a majority shareholding by historically disadvantaged persons. The conditions also address information exchange concerns between Heineken and Distell. We also imposed public interest conditions which included, amongst others, the establishment of an ESOP that introduces shareholding to employees. We heard seriously concerning allegations from witnesses about alleged human rights violations and the ill treatment of temporary and seasonal farm workers, including women on farms whose working conditions were appalling. They had no access to ablution facilities, having to substitute trees for toilets. We could not turn a blind eye to this. We imposed conditions tendered by the merger parties to investigate these allegations and to take the necessary remedial steps and to report to the Commission, which will monitor the conditions. A developing trend in mergers is an increase in sweetener conditions proposed by parties to get the deal through. Examples of these sweetener conditions range from performing free surgery, addressing surgical backlogs in public hospitals, financially supporting the upgrade of clinics and mobile health units in underserviced areas, to commitments on human rights. We have imposed these conditions. Our approach has been to satisfy ourselves first that there are indeed competition or public interest issues, and thereafter we consider whether the conditions could be said to be shockingly inappropriate, and if the conditions contribute to a positive change in society, we have imposed them and tightened the conditions to ensure enforceability. The benefit of our competition law regime is that these public interest considerations are done transparently in public hearing, as you know. Turning to prohibited practices, from inception to date, the tribunal has decided 32 interim relief applications. Almost half, about 40, of the cases related to abuse of dominance allegations. About a third, 10, related to allegations about both abuse of dominance and vertical restraints. 5 related to allegations of abuse of dominance, vertical and horizontal agreements, and 2 cases related to allegations of vertical and horizontal restrictions, and only 1 case related to collusion allegations. It is not surprising that the majority of interim relief cases in which the tribunal has been called to rule upon have dealt with allegations relating to abuse of dominance. In dominance cases, the core concern is the exclusion of rivals, which is damaging to the competitive process and which, once it occurs, may be hard to reverse. As some, if not many of you may be aware, the tribunal's powers to grant interim relief have gone through 2 legislative regimes. Initially, interim relief was catered for under the erstwhile Section 59, which was repealed by the Competition Second Amendment Act in December 2000, which ushered in Section 49C as we now know it. The requirements under Section 59, the old regime, and Section 49C, the new regime, are similar except that under Section 59, there was an additional factor in considering whether to grant interim relief, and this factor was whether interim relief was required to prevent the necessary sorry, I got distracted there. Whether an additional factor was to consider whether interim relief was necessary to prevent the purposes of the Act being frustrated. This requirement was dropped in the new Section 49C regime. The second difference was the applicable standard when determining interim relief. Under Section 59, the standard was on the balance of probabilities. In 1 year, between 1999 and December 2000, the tribunal decided 5 cases. 4 were granted, and only 1 was dismissed. Contrast this to the standard under Section 49C, which is that a successful applicant is required to make out a prima facie case of a prohibited practice, a change from the previously adopted practice of on a balance of probabilities. This had a chilling effect on interim relief. Between January 2001 to December 2018, under the new regime, the tribunal decided 18 cases and dismissed 16 after finding no prima facie evidence of a prohibited practice. Only 2 interim relief applications were granted. The new regime clearly led to fewer interim relief applications being granted. One of the policy objectives of the 2019 Competition Amendment Act, is to open up the economy to greater investment in new businesses with a focus on opening up markets for SMEs and Black-owned business. Following the inclusion of participation in the definition of exclusionary act, we are seeing a third wave of interim relief applications, as evidenced by the fact that since 2019, when the amendments were passed, the tribunal has decided 9 cases. In 5, we granted interim relief and we dismissed 4 cases. We are definitely seeing an increase in the number of parties coming to us seeking interim relief and complaining about being excluded from the market. They are relying on the new provisions. In the past, an exclusionary act meant conduct that prevents a firm's entry or expansion within a market, but now also includes conduct that prevents a firm from participating in a market. Participation means the ability of or opportunity for firms to sustain themselves in the market. The debate now is whether a firm can say, I'm a small firm or a Black-owned firm that is being excluded, and therefore I require interim relief for a short period of time because the dominant firm is refusing to deal with me. This issue has been considered in recent interim relief applications, and the difficulty seems to be whether exclusion in and of itself is enough of a prima facie prohibited practice. This is not made easy by the fact that in these cases, there are often disputes about the relevant markets, about dominance, about exclusionary conduct, and anti-competitive effects. While the CAC has provided guidance on this, there are still some gray areas as to what is required to show prima facie evidence of a prohibited practice in abuse of dominance cases. In e-media, the CAC said, what is required is a clear, non-speculative, and uncontroversial facts that support the prima facie finding of a prohibited practice. And that whilst there will inevitably be disputes of fact, that should not prevent the tribunal from taking a robust approach on the evidence before it. But what is this robust approach? Our view is that this can only be determined after a careful consideration of the theories of harm and the evidence available to us at the time of analysis. In abuse of dominance cases, it is often difficult, even after a full-blown investigation, to assess whether there is an anti-competitive effect. More so in interim relief proceedings. Relying on standards set in SAA and CompuTicket may set a high bar for interim relief. Under this standard, the requirement of a substantial anti-competitive effect is met if there is evidence of actual harm or consumer welfare, or if the exclusionary act is substantial or significant in terms of its effect in foreclosing the market to rivals. The question is the standard appropriate at interim relief stage? Because it requires a consideration of a counterfactual, which is, absent the conduct, what would have happened? At interim relief stage, such evidence is seldom available. Should the standard rather be whether or not the anti-competitive effects are non-trivial, as the CAC has also found, and whether the respondent can justify its conduct? These are the questions that the tribunal grapples with in matters coming before us. It is not all doom and gloom. A balance is obviously required. From a policy perspective, interim relief is an important tool designed to deal with imminent harm to competition, to regulate market conditions during the investigation period, and to improve the overall effectiveness of competition law enforcement. At the same time, interim relief becomes toothless if the bar is set too high. Turning to market inquiries, another aspect of work that is worth noting are appeals from market inquiries. Market inquiries are meant to address concerns relating to economic concentration, among others. These are early days, but following the conclusion of the Commission's recent market inquiry into digital markets, appeals are starting to come in at the tribunal. At the same time, parties have brought review applications of the Commission's decision in the High Court. This may delay implementing the recommendations of the market inquiries whose outcomes are intended to promote competitive markets, transformation, and deconcentration. However, this is part of the due process, and parties are entitled to exercise their legal rights. Given the rapid and fast-changing nature of digital markets, it is critical that these matters are dealt with expedition, lest the object of the inquiries are defeated. In conclusion, it is not expected that our work in pursuit of competitive and inclusive markets will result in overnight changes to transforming the economy and levels of participation by SMEs and HDPs in South Africa, nor indeed to solve the economic problems I mentioned earlier. But the work of the competition authorities is an important building block. As Martin Luther King made the observation, all progress is precarious, and the solution of one problem brings us face to face with another. Still, we must persist to solve the next problem. The work we do is about incremental changes in the quest to create economic possibilities for our grandchildren in today's era. By adopting a context-sensitive, transformative constitutional approach, which is consistent with the scheme of the Act, we contribute significantly to South Africa's transformation goals, one case at a time. Thank you for the opportunity, and I hope you will find today's program fruitful and insightful.
Thank you very much, Mondo, for those words. I really truly do believe that the work of the Competition Commission and the Competition Tribunal is very important. And I mean, I think the latest judgments have not been too great for us, but we should not allow ourselves to be derailed. We have a very important role to play for the people of this country. there is high concentration, ownership still vests in the hands of the minority. We have the majority that we still need to open up markets for. So it may look gloom, but we should not give up and we should not derail. There are lots of people and businesses and young people out there that are relying on us to change the status of this economy. I would like to welcome on stage now Norman, who is going to speak actually on a very important topic. It is whether or not Competition Act has survived its challenges 25 years later. Have we achieved what the objectives of the Competition Act have sought to achieve? And I hope, Norman, you have a good story to tell. I think we are all looking for that good story. So as Norman comes up, I just want to quickly introduce him. Norman is the judge president of the South African Competition Appeal Court. He's also a former chairperson of the South African Competition Tribunal. Norman is also a professor of practice at the University of Johannesburg. Can we please welcome Norman Manoyem to the stage?
Thank you very much, everybody. Thank you to the Commission and the Tribunal for inviting me to be here today. Conferences have got a lot fancier than when I was here. I see my photograph up here from a few years ago. I've clearly got a lot grayer since then, but I still seem to be wearing the same tie. So some things haven't changed. Actually, when I last spoke at the conference, I was given the unenviable task of saying the thank yous at the end. And I was given the job to speak after Trevor Noah, who was much poorer then and the Commission were much richer then, so they could afford to have him. And so Trevor Noah decided as his satire of the day to make the thank you speech. So he satirized everything that I was going to say immediately thereafter him. So I hurriedly had to change my speech completely in saying, thank you, Trevor Noah. I have nothing more to add except to say, thank you, Trevor Noah. Fortunately today, Mondo has given a very erudite and serious speech, so I don't have to just say, thank you, Mondo, and exit the stage. I've asked to speak today about whether the Act has worked. And we've got a habit at these conferences of finding some anniversary that we can tie the speech to or the theme to. It's very useful because the Act came into being in 1998. That's when the President signed it, in October 1998, but only came into operation the following year. So we've got this choices of these 2 years to decide when do we celebrate. So I've opportunistically taken advantage of the same thing to say it's 25 years now since the Act was signed into operation by the then President. Has it worked? So let's look back at the Act, and it's now in this lovely booklet that the Competition Commission gives us, very helpful. And I looked at the Act and I see that since 1998, the Act has been amended 7 times. That would suggest that the Act hasn't been working all that well, and you're having to call in the builders every now and then to fix up the plasters that have been cracking. Perhaps that's a bit unfair, because in a sense, all new legislation has its problems, and we don't see these things, and we need to fix them up. And the second thing is that markets change, so does competition legislation need to change, and you need to address those conditions. And in effect, only on 2 occasions, most recently being 2019 amendments that Mondo talked about, has there been a substantial change to the working mechanisms of the Act. But if we look back at the predecessor, the Maintenance and Promotion of the Competition Act, there were a number of things there that were wrong, which we try to rectify in the new Act, and I think are still there as the main features. The first is the competition authorities were not independent. In fact, the Competition Board, as it was known then, was an advisory body which had no power except to advise the Minister of Trade and Industry, who could then decide whether to implement its recommendations or not. So it was an administrative lawyer's dream if you didn't like the decision of the minister, because the minister had heard none of the evidence and had just read a report and made a decision. So it wasn't hard to set that aside, particularly in our new constitutional dispensation. The second thing is that cartel offences were criminalised, and the Competition Board said, therefore, it had no jurisdiction over it. So the only case that I found that dealt with cartels was a furniture cartel that had cartelised to prevent First National Bank getting lower charges when it moved to its new premises. And they were charged in the Magistrates' Court. Surprise, surprise, the furniture rumours got off as well. More recently, there have been cases against the furniture movers, and I think in the most recent case, they got off as well. It just shows that the Act may change, but furniture removal remains the same. So the new Act brought in the three authorities, the Competition Commission, the Competition Tribunal, and the Competition Appeal Court. Secondly, it gave them powers. It gave them administrative powers to sanction. So the Act gave these authorities teeth. The third thing there was an important feature related to mergers. Previously, it was not compulsory to notify a merger to the Competition Board, and even if you did, there was not much it could do about it, except to recommend to the minister. The new regime said not only is a notification compulsory, but it must be pre-merger notification. This was met by the business industry with absolute horror. And there were talks at the time that there should be a boycott. Nobody should notify mergers, and we'll see if the system cracks. Well, business cracked and the system did not crack, and we've now got used to living with the idea that there is compulsory pre-merger notification. It is, in fact, as Mondo said, the most transparent of merger regimes. Take Sibanye-Stillwater. It was a merger between a South African firm and a US firm in the platinum market. Sibanye-Stillwater had to notify the merger in South Africa and climb through the usual public interest conditions. It also had to notify in America, but in the United States, it had to comply with something called CFIUS, the equivalent of the US public interest in the United States. They may tell you that they have no public interest considerations when it comes to merger. That's not true. They just do it under different legislation. But in South Africa, if you wanted to know what was going on with the Sibanye-Stillwater issues and its public interest issues, that was transparent. CFIUS was, as one American lawyer has commentated, is like a black box. It is secret, you don't know why, and you get an outcome. So our public interest conditions, controversial as they may be, have at least the virtue of transparency, institutions that deal with them in different ways, the Commission, the Tribunal, if you want to the Competition Appeal Court, and finally, if you want to go to the Constitutional Court. So you've got a transparent and institutionally strong system, which I think is the greatest virtue of our system, and I'm always proud of the way our merger control works. I know people say it takes time. I know people say it's got enormous uncertainty. But in terms of the way it engages people in the system, the rights it creates, and its transparency, it is, I think, one of the most foremost merger systems in the world. So I think the institutions have stood the test of time and they've worked well. Perhaps my institution is the one that has, in a sense, encountered the most difficulties, because the Competition Appeal Court was initially envisaged to have 3 judges and 2 economists, and that was the Act in its original form. When it came to the Judicial Service Commission deciding whether they should appoint economists to the court, they said, horror of horrors, we should not put economists on a court. They are not judges. They are apparently some inferior species called economists. Therefore, they should not be there. And so we had to amend the Act, because at the end of the day, the JSC decides these things rightly or wrongly, and economists were excluded from the court. So what is otherwise said in the Act to be a specialist court became, unfortunately, a court of appeal, but couldn't claim to be specialist courts. And as things have happened, there's been a rapid transition of judges, other than my predecessor, Dennis Davis. There's been a rapid transition of judges in that court either into retirement or into some higher court. So the consistency of experience in that court has been and remains a particular problem. We've got some ideas to try and address that, but that has been a problem for that institution in terms of, was the original conception now met by the current reality? The same criticism can't be made of the Commission and the Tribunal, and in fact I see, and I think it's a very good thing, that the Tribunal now has 6 economists out of its 11 members, if I look at it correctly, and that's probably the highest as it's ever been, and I think it's correct. And I may say, against my own profession, that economists have taken better to law than lawyers have taken to economics. All the economists are going to have tea with me afterwards. There are obviously a lot of economists in the audience. They're the only ones who are clapping. All right. So then let's look at other things. What's happened with process? Because process matters. Process is about how you get a complaint to finally get adjudicated upon and get a solution. Well, process went very badly in the beginning. And there were 2 horror cases, which I can point out to you, where process seemed to be looking very, very bleak in the middle years of our 25 years. The first case involved the Commission's first cartel case of significance. Of significance, I want to say, because cartel cases up until then, or Section 4 cases, because Section 4 doesn't use the word cartel, but we all understand what it is, were aimed at professions. So professions had rules were public documents, and they were low-hanging fruit to say the attorneys, the advocates, and even the vets, poor people who look after your dog Rover, even they had rules which were collusive and had to be dealt with. What wasn't apparent at the time were the hidden cartels, the more sinister private arrangements, fixing prices, dividing markets. So the Commission got a tip-off that in the cement market, cartels were operative. So the Commission at the time, this was 2000, very enthusiastic, decided to do this, have what we call a dawn raid. In fact, it wasn't dawn, it was 9 o'clock in the morning. Maybe for people who work for the Commission, that was dawn, I don't know. And they raided the offices of 2 of these firms. And following US style, they decided to introduce the perp walk. So they had 2 TV crews, one from SABC and one from ETV. The Commission doesn't like to encourage monopolies, they encourage a duopoly. And each of them accompanied the raiding parties and went to these particular firms. And in one particular firm, they asked for the CEO. He didn't want to come down, so he sent his secretary. And the secretary came down. Her name was Cheryl. And there was poor Cheryl emblazoned on primetime TV, flashing expression on her face as she was shown all these warrants for search. Anyway, the firms went to court, and they climbed the hierarchy and went eventually to the Supreme Court of Appeal. And the Supreme Court of Appeal lambasted the Commission, saying, you have violated the terms of your warrant to be private, and while the Commission has important work to do, it must not frighten the horses, was the word in that case by the judge. Not only did they condemn the raid, but they set aside the entire search warrants, and they said the documents seized must be returned to the firm, and as final condition it said no reliance on any information from the seized documents could be used by the Commission again, but it said the Commission must then decide what it wants to do. Well, after that kind of excoriating criticism, the Commission read the tea leaves and didn't do anything at all in that market again until 2009, when leniency had been introduced as part of the things, and a firm came forward and claimed leniency. And what was discovered was, in fact, what was going on in 2000 was quite true. There was a cartel amongst all the cement producers, and it had carried on. It had carried on despite the fact that the old competition board, which had given exemption to cement manufacturers, had ended the exemption, and they carried on covertly. So what was the effect of that court decision on processors? Well, it discouraged for years, for 9 years, the implementation of competition law because a secretary was embarrassed on TV. So instead of giving, perhaps finding a remedy which said, Commission, you've done wrong, but the public interest in finding out if there's cartel is perhaps more important, they set aside the whole raid. And so I often refer to this secretary's plight because we discovered years later that the cartel overcharge during that period, according to the Commission's research department, was at least R1 billion. That this was the $1 billion brush of the secretary. Her embarrassment had cost consumers that amount of money. The second, I think today a court wouldn't give that kind of decision. The court might say the Commission was wrong, and the Commission was wrong in not giving privacy to the warrant. But whether the remedy of the court outweighed the harm that was caused is something I think we'd look at very, very differently today. The second problematic series of cases concerned the milk cartel. So there was a milk cartel when, again, an informer told the Commission, and the Commission had got these fairly, what I would say, fairly clumsy subpoenas and to witnesses. And so even at the tribunal level, we set them aside. But we set aside just the subpoenas. The case eventually wandered its way to the Supreme Court of Appeal in a case called Woodlands. And in Woodlands, the court again excoriated the Commission and said, this is terrible, this can't happen, and set aside not just the subpoenas, but set aside the entire referral. So an entire inquiry into buying power in the milk industry and selling power in the milk processing industry was set aside and never happened, at the cost to the consumers of South Africa and at the cost of dairy farmers who sold to these firms if there was a cartel. Obviously, it didn't ever get adjudicated, so I was saying if there was one, we do at least know that one firm applied for leniency. It was the major firm in the industry, and we do know that one firm called Lancewood settled. So there was at least smoke at least around that. But what happened on Woodlands was not so much the decision, but its subsequent effect, particularly on my institution, the Competition Appeal Court, is that people started taking technical points around referrals, so that unless the complaint, which the complainant brings in, looks exactly like the initiating document in the complaint referral in the tribunal, they would say, no, 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 this must be set aside. And the Commission would have to go back to the drawing board, and usually when it got to the drawing board, the case had prescribed. So there was a whole series of cases around this where everybody worth half a law degree would take this point against the Commission when it brought one of these cases. And it took some years before the Supreme Court of Appeal, as it were, deflected its own carriage of process that it started and said, no, 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 the Competition Appeal Court has misunderstood our earlier decision and got it wrong. So it seems to me now that that series of fashionable challenges is no longer there. And so process, which was very much under threat for about 6 or 7 years during this interregnum period, has now been rectified. As far as abuse of dominance cases themselves are concerned, we probably do have not as many abuse of dominance cases that we would have liked to have got, given the nature of this concentration of the economy. Quite why that has happened, I don't know. Perhaps because abuse of dominance cases are so hard to get, so hard to drive, and so fact-driven. But there have been some very, very important successes. And in fact, the two of the greatest successes of the Commission during this period are what I call the Hazel Tower case, which involved the pricing of antiretrovirals and led to a settlement of enormous implications through sub-licensing by the relevant firms, Glaxo Wellcome and Boehringer Ingelheim. Enormous importance to the people affected. And I remember Zaki Ahmed, who was one of the people affected, speaking at one of these conferences saying what the difference in prices meant to him as a consumer. The second followed an 11 or 12-year battle between the Commission and Telkom about access to to internet services. Again, it resulted in, for various reasons, both, one never knows exactly what the factors are that drive it. But one of the best settlements in terms of its effectiveness and in terms of its breadth of effect on consumers was a settlement achieved between the Commission and Telkom in relation to the internet service provision and separating out the structure of Telkom's business, which leads today. So whereas for years Telkom was the bully in the market, Telkom now is in fact a much more modest firm, should we say, than what it used to be. And that was a very, very important intervention brought by the competition authorities and not, as you might have thought, by the sector regulator to whom that primarily represents. And then there are all sorts of reasons for that. But I think the strength of both the institutions and the reputation of the Commission for being willing to take on the big guys fearlessly helped to do that. Cartels have been, as I say, an area that slept for many years until the leniency policy was developed. And then there was a flood of notifications to the Commission. And the Commission has been spectacularly successful in relation to the bread cartel, in relation to this construction cartel. Perhaps less successful in relation to bid rigging cases, and I'm not quite sure why, but those are important cases because that reflects public sector procurement at a time when the fiscus is running out of money. So if there's an overcharge as a result of bid rigging to the public sector, this is a very weighty public interest indeed. But cartel enforcement has gone well. The one criticism I perhaps would have of the Commission is it's tended to be very one-sectioned. What I mean by that is it tends to go for Section 41B only and never for Section 41A. So we've got this monster called characterization, which people at the Commission do not like very much, and which respondents charged in the cartel case like very, very much. And they say, no, this isn't a Section 41B classically because you need to characterize this thing. What characterization really means in simple terms is that the legal form may look like a cartel, the economic form, it really isn't a cartel. It's really the basis for that kind of argument. But it's got fairly complicated and has been used in many instances. But if the Commission relied on Section 41A as well, then that firm, even if it was characterized as they want to characterize it, would still have to persuade on the justification that the anti-competitive effects did not outweigh the pro-competitive gains. And so the Commission would have another tool in this toolbox to actually deal with that. So I think that needs to be given some consideration. I think in relation to mergers, I think Mondo has given a very good explanation of mergers and what has come before. To me, there have been two great successes in merger control. Those were the J.D. Elleren's merger, which was prohibited by the tribunal right in the beginning between furniture groupings, and secondly, the Sasol Engine merger, which was a merger between the greatest refinery company in the country and the greatest retailer. And it was opposed, a long 19-day hearing, the merger was prohibited. There have been a number of setbacks. The biggest setbacks have been in the healthcare sector, because we've had what's called the creeping merger problem. In other words, the three big hospital groups have all at various times brought small hospitals and taken on their own. Those small hospitals have not been, if you set a substantial listening of competition standard, they didn't meet that standard. So before you knew it, the big hospital groups had chewed up most of the independent healthcare sector, which was quite healthy in this country. That has been addressed in some way by the 2019 amendments by the so-called creeping merger provision. And we'll have to see how that works out in the future. But that certainly has been a failing, particularly in the healthcare sector, from what we had in the past. What do I say about the public interest? Well, I've got to be careful what I say about the public interest, because in a sense it's driven by the legislature, and the legislature must put in what it sees fit. So I must just talk about, as a judge, about How does one evaluate the public interest when it arises in a merger? And it seems to be arising in virtually every merger. The problem is, what is the standard? What is the legal standard? Lawyers use the term justiciable. Is there some legal standard you can say that when Burger King wants to buy another business, it must go for the Big Mac solution, excuse me for confusing metaphors and products, and replicate its original structure of what it was before the merger at the very least, plus more, the Big Mac solution? Or must it find some other way of little franchises getting some bite of the thing, and we have the veggie burger solution? Less compelling and less tasty to the original thing. Now, if you had a legal standard to decide that particular debate, or no burger at all, it's very difficult to decide what that would be. So it's surprising then that that hasn't been challenged, given that there are a number of mergers notified all the time and that these are well-resourced people. And the probable answer is that merging firms want to get the deal through. And so what we've moved from is a system where you have justiciability in relation to mergers to some legal standard, whatever that standard might be, to a system where there's a bargaining taking place. And effectively, that's what it's become. People come along and you're asked, what are you doing about the public interest? And you say, well, I can do this and this and this. And they say, well, what are you doing about that and that and that? What are you doing about promotion of ownership to historically disadvantaged and to workers? And people will say, well, we can throw in this and we can throw in that. But there's no standard which you can say, the law says you must do this in this situation. Or the law says, what is the evidence that would be needed to have that particular case? So absent that judicial standard, it means that the system is no longer one which we can say is justiciable in terms of some principle of law, but is in fact much closer akin to a wage negotiation. Parties bargain, reach some outcome, and then as a result of that bargain, accept that, and then go ahead. That doesn't mean that public interest hasn't done good things. It clearly has done good things. The question is, speaking from the court's perspective, as a matter of law, do we know how much of a good thing it should be and whether there should be a good thing at all? And those are the challenges that we faced with that particular system. And eventually a case will come up which will, in some way, will have to come up as a decision about it. Of course, it's not only in public interest in mergers that these problems emerge. It emerges in constitutional analysis. You have to weigh up freedom of speech versus privacy and dignity. How much of each do you allow? Well, that depends on the circumstances of various cases. There are no clear-cut answers to those. But I am concerned that this may have the perverse effect of moving away. Let me just then say on market inquiries, because the tribunal and the court have got very little experience of that, I'm not really in a position to make some comments about that. I was pleased to see that in relation to the online intermediate market, I think it's got a very unsexy name, guys. Think of a better name. Call it the Google Bashers or something like that. It was done in 2 years. Had it been more focused and less ambitious in its scope, would have happened more quickly in a more focused way than it was. Civil cases, you can sue in South Africa for competitive loss. Very few civil cases, reasons I'm not sure of. There was one brought against SAA by 2 airlines who are no longer in the sky. So make of that as you wish. They succeeded against SAA, got money, but weren't there to enjoy the money in terms of putting planes into the sky. There was a different settlement with the construction companies, orchestrated by the ministry, that may have had good outcomes. There was a different one, I think, went to civil, to arbitration with the Cape Town Council. Again, not sure what the outcomes, they're not public. So civil action brought us the class action for private damages came out through a competition case against the bread companies, good things from that, but in terms of actual remedy as inhibiting cartel practice has been unsuccessful. Most disappointing of all has been criminal cases. I don't know if there's been a single criminal case since the provisions came into the Act in around 2009. Not one. Why is that? Bad design. Bad design because the prosecution can't start until there's been a finding by the tribunal that the firm involved was in a cartel. So the great virtue of criminal prosecutions is the power given to prosecutors is not given to them up front, only afterwards. And so you charge the directors for a crime that the company has committed. So it's this disjointness between the way they conceptualized the criminal provision versus the civil provision. And as a result, people, particularly in these bid rigging cases, can get off a defense which probably looks, I'm not a cartel, which may actually be fraud. Fraudulent representation to the firm that put out the tender. That they couldn't get away with if the prosecution could charge them with bid rigging in terms of the Section 4 of the Cartel Competition Act, as well as alternatively fraud, because sometimes they've slipped through the one gap to get the other. And that has weakened public sector enforcement against bid rigging. And so I think this needs to be rethought completely, and the NPA should be given these powers de novo from day one. Of course, it must work with the Competition Commission because they've got the expertise. But at least in public sector procurement cases, that's a very, very important way of enforcing competition law and public sector procurement at the same time through the same body. Finally, I just want to make a general point as have been successful. I think it's important to realize that there have been setbacks all along, but every time the Commission and the Tribunal have got through those setbacks. And there will be setbacks again, and days when you think we can't do anything. It's very important to know that there have always been victories, and that the long game has eventually triumphed, and that the good guys have won over the bad guys. And I wouldn't want to leave people with a message that because some things haven't worked, that nothing can work. In fact, quite the contrary is the case. There's been resilience, there's been courage, there's been determination, and to do that we can make sure that we have a more competitive economy and that we remember who we are working for. Finally, just on a very personal note, and a note of personal pride for me, is a great feeling of warmth that two of people who once article clerks, as they were politically incorrectly called at the time, and now they're called candidate attorneys, I believe, who were once in my law firm, are now the big bosses of the Competition Commission and the Competition Tribunal. And I think it's great that they've worked in this area, they have persevered, and through their abilities and talents have now got the top jobs. And for me to hear them speaking and be at this conference in charge is perhaps, to me, the greatest feeling of achievement that I've had in the 25 years. Thank you.
Thank you very much, Judge President. I think there's one thing that I should mention. I was listening to your speech quite carefully, and you mentioned furniture removals and how they've managed to escape conviction. And what he forgets to mention is that the last case that he talks about, that the furniture removal companies escaped, was penned by him. And I mention this in particular because after an emphatic, and I say so myself, argument delivered by myself, he still did not hear me. And yes, Norman, I'm still cut by that. Ladies and gentlemen, we are going to break for 15 minutes for tea. I think for those that have been here, you know where the tea area is. Thank you very much.
Thank you.
Thank you very much, Karabo. We are slightly behind schedule, 7 minutes behind schedule. and I'm starting to suspect that I've been set up by my lovely lady next to me, because the time that I'm supposed to be keeping time happens to be the same session that is led by my other boss. So I'm not necessarily saying that we are running out of time, but I'm saying it, and that's why I'm not looking at him. So perhaps I should begin by saying this, that in 2015, a study was conducted that estimated that in the first 6 months of 2015, we lost an estimated revenue of about 72 billion rand due to load shedding. Now, I mention this in particular because this next plenary session is titled Development of Competitive Energy Markets. And with that being said, and I do not want to waste more time, I'll hand over to Professor Liberty Ncube, who's the Deputy Chairperson of the Competition Tribunal and the moderator of this session.
I thought I would start by noticing that the picture they have used is a picture which is of a younger me, and a picture that shows me wearing the same tie, just like the Judge President. I have become grayer, as you can see, and I've become wiser. So that is no longer me. Welcome to this panel discussion on developing competitive energy markets. My name is Liberty Ncube, and I'm the Deputy Chairperson of the Competition Tribunal. I want to extend a warm welcome to everyone who's here with us, but also to those that are watching online. South Africa has enjoyed power cuts for years now. This has been a result of an aging coal-fired power plants, which continuously break down. In February this year, President Cyril Ramaphosa, in his State of his Nation address, called the South Africa energy crisis an existential threat to the economy and to the social fabric of our country. And when he then went on to say, government's most immediate priority is to restore energy security. So it appears that resolving the energy crisis may require improving Eskom's energy efficiency, fostering competition, and accelerating the rollout of renewable energies, among others. I have with me today a truly dream team of panelists. And what I thought I would do is to start with Khanyisa Qobo, who is the divisional manager responsible for advocacy at the Commission. And then I'm going to move on to Professor Pratapan Mutli, who is the general manager and also heads the Energy and Research and Development and Innovation at the South African Energy Development Institute. Thereafter, I will introduce to you Mark Nefer, who is a lawyer and an economist working at the Antitrust Division at the Department of Justice. We are going to be joined online as well by Dr. Pierre Horner, who is the Economics Affairs Officer at the United Nations and Social Commission for Asia and the Pacific. So let me start with you, Kanye. The Advocacy Division interacts a lot with government and policymakers. Are the policy interventions by government adequate to get us out of the energy crisis?
Am I audible? Yes. I think, on a question of adequacy of policies, we always come out tops in South Africa. If there's one thing we are good at, it is policy design. The question is really around implementation of these policies. If we just go back to the dawn of democracy, we had a situation where over 80% of the population was without electricity. So you had the Integrated National Electrification Program in 1994, which was mass electrification program. And this was successful. I mean, by 2014, there's some good statistics. I think something like 80 or 82% of the population or households had already received electricity. But this program was being rolled out by a monopoly which had its own set of problems, right, on capacity, governance issues, and of course, without the requisite investment in infrastructure. And so we are here today partly, reaping the fruits of that program by government, but also the lack of investment in meeting that demand. So the current policies on unbundling ESCOM are looking to essentially correct some of those challenges. We then move on some 17 years later. In 2011, they introduced the Integrated Resource Plan. And this is the first policy that sets the framework for the diversification of energy sources, where the plan or the policy is to also introduce renewables and also nuclear into the mix over and above coal, which is the predominant source of energy for electricity into the grid. And this IRP is upgraded or updated periodically to demarcate or proportion the generation allocation between those different sources of energy. So the last one, I think it was 2019, if I'm correct, the last valid IRP. So the IRP then forms the basis of the renewable energy IPPs, the REIPP, which is to introduce independent power producers. And so at this point, of course, we have a shortage of electricity. We have rolling blackouts. And so the implementation then of this REIPP or triple IPP, although it was set in law as far back as 2011, but it's being implemented in a context where essentially you're facing down the barrel of a gun. And so there are policy tensions in that regard as to how much of that allocation should be going to IPPs versus coal in the context of a shortage of demand. And then in parallel, and probably towards my conclusion of this policy context, you have the Just Energy Transition, the JET. This is a policy framework to accommodate the climate commitments that we've entered into. So the United Nations Sustainable Development Goals, the Paris Agreement. And again, I mean, there is international pressure here. I think the approach of the developed North versus the developing South on some of these issues or emerging economies is a contentious and contestable issue. But the commitments are there in the form of foreign direct investments and grants amounting to billions of rands to support projects for clean energy, many of them located in Mpumalanga, which is the coal belt of the country. And so I think there are these policy tensions at the level of implementation around the rate and pace of how some of these new forms, alternative forms of energies are being introduced in the grid relative to the primary source of our energies, which is coal.
Thanks, Khanyi. Let me move on to Professor Moodley. What, in your assessment, would you say are the contributing technical factors that are part of South Africa's energy crisis?
Thanks so much, Prof. So I think it's quite interesting to appreciate what we have in South Africa from an energy perspective or power perspective. And just to give some context, the South African power system is about 54 gigawatts, and 54 gigawatts is about 50% of continental Africa. So literally, if you add up every single other country, 50-odd states in Africa, excluding South Africa, you would make up the power system that's in South Africa. It is massive. Globally, a few years ago, about 3, 4, 5 years ago, the ESCOM system was probably the top 15 largest systems on Earth. So we're not talking about a small little system that's in the southern tip of Africa. It is a very large, complex system that we actually have. And I think, as my fellow panelists indicated, it's quite important to appreciate that at the very beginning of democracy, and as we kind of opened up the market for economic activity by all citizens of this country, there was a huge amount of growth. There was economic activity and so forth, and GDP rose significantly. Part of the GDP growth required, in part, a lot of energy and energy security to support these new businesses, new enterprises, new industries. And at the time, what we found was that the energy infrastructure has to be planned over a very long period of time. At the time, conventional technologies like gas and coal and nuclear lasted about 50 to 60 years and took about a decade to build. So as you see this challenge coming in terms of running out of capacity, you have to be planning at least 10 years, if not more, ahead to add on this capacity. So it's quite important to appreciate that the consumption of energy to support this economic growth had significantly ramped up, and we needed, as a country, to add a lot more capacity. Added to that, we've got new pressures and policy commitments, and these are really good commitments, right? So the just energy transition is something that says, how do we go from this very polluting type of energy resources to something that's far more sustainable, far more better for the environment, but far more better for all citizens that actually live in the country. And why I say that is that, if you cast your mind back a few years ago to COVID, you'll recall when the whole world went into a global shutdown, the environment recovered literally within a few days. Probably 2 weeks, it cleaned up itself. But the long-term impacts on people, human beings, in terms of respiratory illnesses and so forth, from dirty, polluting technologies has major impacts on the lives and livelihoods of people, but also has a big impact on things like the state and its health sector. So as we go through the transition, it's important to bear in mind that unlike kind of the very developed world and generally the global north, they have a very stable power system, and all they're doing is fuel switching, which means they're taking out the coal, they're taking out the gas, and they're switching it to other technologies. In developing countries like ourselves and our BRICS partners, we've got this growth of energy demand, and as we fill up the growth, we also have to switch, which is kind of a double conundrum. So where we got to was, I think in the midst of 2008, we had the first bout of load shedding. And it is really symptomatic of kind of long-term planning and long-term implementation. And solving this kind of short-term crisis of load shedding requires lots of investment for lots of infrastructure that typically lasts anywhere between 25 years, which is renewables, wind and solar, but 50, 60, even 80 years with technologies like nuclear. And that's why we have policies like IRP, which gives a lot of certainty on how we choose these technologies and how do we get towards making sure that there's enough capacity to support economic activity, but also making sure that as we transition as a country towards cleaner, low-carbon resources, and that's very, very critical. So also quite importantly, these technologies don't compare like for like. So a dispatchable technology, be it coal, gas, or nuclear, can run 24/7. Technologies like non-dispatchable technologies like wind and solar are highly dependent on the resource. So, when the sun shines or when the wind blows. And I would really encourage you guys to go and have a look at the ESCOM data portal just to talk about the variability. Interesting this month was quite an interesting one, where last week we had lots and lots of wind capacity because the wind was blowing. 2 weeks ago, there wasn't any wind on the system. And that's part of the complexities that you have to manage in this transition of this electricity system.
Mark, let me just introduce you to this topic as well. From what, in your view, if you look at the US, where you have some experience in transitioning to a liberalized energy market, what can South Africa learn from the US?
Thank the Competition Commission for inviting me to participate. This is really a valuable opportunity for me to learn as much as anything. Before I get started, I need to say that the views I express are my own and not necessarily those of the Department of Justice Antitrust Division. So with all of that out of the way, as I thought about my answer to this question, and I thought about some of the lessons that the United States learned during restructuring, it occurred to me that over the last 3 decades, there have been a number of jurisdictions that have tried to restructure their markets, and there are a number of lessons that have come out of those efforts as well. So over the last 3 decades, around the world, we've had a substantial amount of experience restructuring electricity markets. And although I'm going to talk about some of the lessons that the United States learned, I think one very obvious and very simple lesson for reformers in South Africa is to study history. That's good advice in many, many contexts, but I think it's especially good advice in the context of restructuring electricity markets, because we have now 3 decades of experience, and I think one of the advantages of South Africa undertaking its reforms now is that it can take advantage of that learning. So I would definitely recommend that you consider experiences around the world over the last 3 decades. With respect to restructuring in the United States, just to give you a bit of background, restructuring took place largely in the middle 1990s. Before the 1990s, we had largely vertically integrated monopoly utilities who had monopoly service territories. Post-restructuring, we've had competitive wholesale markets with transmission that still continues to be regulated as a natural monopoly. Although we've restructured a large part of the United States, perhaps 2/3 of the country now gets its electric power in restructured markets, we still have 1/3 of the country that's subject to traditional cost-based regulated vertically integrated utilities. So in the areas where we have competitive markets, the markets usually consist of spot markets for power, bilateral markets for power of varying durations, ancillary services markets, things like spinning reserve markets, black start markets, and usually capacity markets. One really painful lesson that has emerged from our experience is that the electric power industry is incredibly complicated. The technical aspects alone of dealing with electric power are just incredibly complicated. You have to be a full-fledged electrical engineer to fully understand power flows and the way power gets from generators to consumers. On top of that, restructuring adds competitive markets, which themselves can be complicated. The development of spot markets, for example, requires very complicated rules, and often there are day-ahead and real-time markets that deal with allocating electricity in real time. In addition, coincident with the rise of restructured power markets and power flows, we have financial markets and financial products that are based on physical electricity markets, and those also can be incredibly complicated. So spot markets are good things, contracts are good things, but they can be, for an outsider, an attorney like myself, to fully understand. So because these markets are so difficult to understand, it's really important to understand what you're doing when you're restructuring a market. Getting market design right is critical. But the even more valuable lesson, I think, is that getting market design wrong is just profoundly costly in a couple of ways. The classic example of this in the United States is the California electricity crisis from 2000 and 2001. Although that's a long time ago in the eyes of many, it's not so long to me, being one of the older people on the panel here. But it's a really valuable cautionary tale about the importance of taking your time to get market design right, because they got it wrong in California, and it was extremely costly in many ways. There were a couple of things that, a couple of features of the market that were not especially well designed. There were many features of the market that were not especially well designed. I'm just going to point to two. One is that the initial design in California called for all power to be bought and sold in a spot market. And it turned out that those spot markets were incredibly easy to manipulate. It was incredibly easy to exercise market power in those spot markets. So that was one problem, poorly designed spot markets. A second problem that exacerbated the first problem was that load-serving entities, the retailers who bought power on the wholesale market and then sold it to customers, were not allowed to enter into long-term bilateral contracts. Long-term bilateral contracts are one way to hedge power risks, and in particular, had LSEs been able to engage or enter into long-term bilateral contracts, typically at fixed prices, they would have been able to avoid some of the price spikes that took place in spot markets in California. So putting those two things together, what you had was market manipulation, which led to a spike in prices on the spot market. You had LSEs who had to buy on the spot market and also had to sell power at retail at capped prices. So their prices were fixed. They were paying these incredibly high prices in the spot market. This led to substantial financial difficulties for many of the LSEs and the bankruptcy of one major utility in California. My own personal view is that the California electricity crisis set back electric power reform in the United States several years, and I think part of the reason that 1/3 of the United States is still subject to traditional vertically integrated cost-based regulation is that the California crisis just scared a lot of people away from competitive markets, which is unfortunate. I'll just mention one other lesson that came out of the US experience, and that is figuring out a way to ensure a reliable and robust transmission system with adequate generating capacity to the satisfaction of the public can be very difficult. And there's a debate that's going on in the United States that has gone on for several years now about how best to do that. One point of view is that you should just rely on wholesale electricity prices to send the appropriate price signals to generators over the long term. So if you have a robust forward power market that gives appropriate signals 5 or 10 or 15 years out into the future, that appropriately incents capacity to be available in the future to meet expected increases in load. That's one point of view. The other point of view is that perhaps bilateral markets are not robust enough to provide the right incentives to generation in the long term, and that there's a need for a capacity market. That is an explicit market that's designed to procure capacity in the distant future to ensure that we have enough power to meet future demands, to meet future unanticipated spikes in demand or decreases in supply. That debate continues in the United States. Both approaches have pros and cons. The one big con of relying on wholesale prices to incent capacity is that you have to let prices rise and fall freely. And that includes letting prices rise very high in some circumstances. So one of the shortcomings of relying on wholesale prices alone is that you're subject to volatility in prices in order for the incentives to work appropriately. Capacity markets have their own problems. We've seen that in some markets in the United States, capacity markets are subject to the exercise of market power. The debate continues in the United States. Some markets have capacity markets, others rely on spot markets to incent capacity. But this is another valuable lesson, I think, is that you've got to figure out a way to incent long-term capacity to meet expected increases in demand. So I'll just go back to my original point, which is there's a lot of experience out there. You should look not just at the United States, but you should also study the history of electricity market liberalization around the world.
Thank you, Mark. Kanye, let me come back to you. Following from what Mark has said, what are the Competition Commission's advocacy agendas that relate to the electricity sector?
Thanks, Prof. I thought that was very insightful. We know the advocacy team did some research on this to draft a position paper in response to the ERA bill, Electricity Regulation Amendment Bill, which speaks fundamentally to issues of market structure and by default to the unbundling of ESCOM as we know it today eventually. And part of that research was, of course, looking at best practices and international experiences in this area. And I think the conclusion truly is to learn from others' mistakes, but ultimately the design will have to be custom to our own set of circumstances. So specifically then on the ERAB, I mean, fundamentally, it introduces the establishment of a transmission systems operator and transmission network operator. So you split generation, transmission, and distribution into three separate components rather than having them as one currently. And so from a competition perspective, we would have concerns about the design of that TSO, that systems operator. Currently, it is still ESCOM. So it is wholly owned subsidiary of ESCOM, and then it's split into three parts. So the TSO is one of the three subsidiaries of the main entity. So we would have concerns about self-preferencing in that context, and particularly for access to the grid by IPPs. We also would have concerns about whether there would be fair outcomes in the bidding process. They are also using a trading platform, at least the network operator is, to source demand and also then to match it with supply. So we would be interested to see how that plays out in practice and whether you don't see then these self-preferencing practices which continue to advantage the ESCOM essentially. Then I think linked with that is issues of pricing. We've seen a steady increase in the price of electricity. We used to have some of the cheapest electricity available internationally, but the prices have really gone up in recent years. And there is a bill out on electricity pricing, it's called Electricity Pricing Policy, which fundamentally seeks to standardize the different tariff methods that are used by municipalities. There's over 250 types of municipal tariffs varying across the board, and so this is looking to standardize the methodology of calculation, and that's something we absolutely welcome and support, and would be working with the energy regulator, NERSA, in that regard, just in dotting I's and crossing T's. We also obviously have seen these emergent markets with the IPPs and also with household solar, and again, we have inserted ourselves in that framework. With the IPPs, it is a bidding market, so there have been these 5 bid windows. So there may be less competition issues because there's price competition that happens at that level. But we have picked up that there may be what you could frame as public interest issues. particularly when there was a shift from a 70-30 split between price and what you can call public interest issues. And it shifted to a 90-10, where 90 was kind of the main determiner for bidding. And so we have heard anecdotally of problems in those local communities around skills transfers, development, and so on, because there's less onus being placed on the bidders to essentially invest in those local capacities. I think a second issue is, of course, the fact that all the bidders are foreign companies, and so there is no local manufacturing capacity. And I think that is a concern for the long term, though we might not frame it as a competition issue in the narrow sense, but it is something we are watching. At that household level, we as consumers in South Africa have had to make a plan, essentially, to minimize the impact of load shedding. And so there's been an upsurge in the use of solar panels, batteries, inverters by local businesses and also by homes. And it has created a new market. There is an association now that's even been established which has begun to do standard setting. It's an import market, so most of these products are coming from other markets, primarily China, Japan, and Canada. And there are some dynamics around that we are interested in. In the top 10 suppliers of household solar products, only one is South African at the manufacturing level of those products. So again, issues then of local capacity. But we are concerned, though, with the absence of regulation, particularly on accreditation and standard setting, which then is being done by industry. So it is something we're watching. Maybe I shouldn't say concern, this word is a strong word, but it is something we are watching because we have had competition problems in the past related to standard setting that have led to forms of cartels. So this is just an area which we would continue engaging or watching and to some extent engaging the association on if need be.
Thank you, Kanye. Professor Moodley, Kanye mentions the establishment of a new transmission structure and some competition issues that may arise. From a technical point of view, what are the challenges that may arise from establishing a transmission structure, and what factors should regulators take into consideration?
Absolutely, I think that's a very pertinent question. So we are very fast moving into a liberalized power system and power market. And the reason I'm saying we're very fast moving into this liberalized system is that many other countries and many other jurisdictions have taken 2, 3, maybe even 4 decades to go through this liberalization process. So it's a very planned process with lots of learnings and feedbacks that then influences policy, regulations, and so forth. In South Africa, we're trying to do this in a very short period, and we kind of have to do it very well planned and accounting all of the risks that come with it. And we don't want market failures. And case in point, there was significant change in systems like Mexico over the recent past. And all of those reforms have been reversed because of some of the risks that came through and was introduced into the market. But to unpack the transmission system operator, the current legislation talks about the transmission company owning all of the transmission assets, which is the lines and substations that you see across the country, but also has this function that is the transmission system operator. In that function, what is envisaged is essentially looking at essentially the day-ahead market and then the ancillary services market generally. I'm not too sure about the capacity market, but it does talk about the central purchasing agency and the single buyer. But those are three very big markets, and I think the capacity market is probably well understood, and we've been running as a country a lot of bidding processes and so forth to bring in new forms of generation technology, generally in the wholesale market. The day-ahead market, which is how do you provision the energy capacity for the demand the next day, in the next 24 hours? That's quite interesting, and for me, technically it seems a very complicated matter, especially in the form of load shedding. So load shedding economically means that you don't have enough supply to meet demand. And currently, there isn't a well-understood merit order, and the contracts that were given through generally the IPPs through the REAP process was a take-or-pay contract, which means that whether the system needed the energy or not, you would take that energy, or you would still pay even if that energy is not used. So essentially, in the 24-hour day-ahead market, the merit order needs to be changing towards a bidding system. Currently, what we see is that IPPs do have 20, 25-year contracts that's fixed prices, essentially, with obviously some type of inflationary increases. Would the community start moving towards a bidding market, or would they kind of rely on the power purchase agreements that still has many, many years to run out, right? Beyond that, I think as we start getting more bidding processes through for the generation market, we need to start talking about having these either sunset clauses in the PPAs or starting to move very quickly to a bidding market. Beyond that, I think all of the IPP bidding process, I think was from REAP 1 to REAP 6 now, have all relied on the sovereign to give a guarantee for all of their 20, 25-year contracts. And that becomes a bit risky for the sovereign, not risky for the generator. And we need to start moving away from that as a country. We need to say that any generation, whether it's renewable, nuclear, coal, whatever the case may be, gas, they need to come in with their own strengths, and they need to manage their own risk and not pass on the risk to the sovereign. So that day-ahead market seems to be something that's very complex to manage. I think it will take some years. I believe that you should not be moving into a day-ahead market under supply constraints, because then you are creating anomalies, and you can obviously create a bidding process because there is shortage of supply capacity. But ultimately, over the longer term, it needs to talk about getting away from PPAs and fixed prices. We need to get to sunset clauses. We need to get into bidding markets 24 hours ahead. And it should be on, the energy should be dispatched on a merit order. We do also then need to go into the ancillary services market, and currently there is a skewing of the market. Generally, we use, from an electrical perspective, we use peaking sources of generation like our OCGTs, like our pump storage, to deal with the peaking and so forth. Currently, they're not being deployed as peaking resources. They're being deployed as kind of day-ahead resources, which creates that skewing of that market as well. So you do need to start thinking about how do you set that up, and how do you make sure that you don't have supply constraints that leads to a bias in your ancillary services market. And we've seen some market failures, right? So very recently, on the top of my head, we've seen failures, short-term failures in the Australian system. We've seen short-term failures in Texas ERCOT system, and that's when you have to have the provisions in the legislation where either the regulator needs to step in and starts taking control of the market until the market stabilizes and so forth. And those are very important lessons learned for this transition. So a lot more on the TSO is required. And I suppose that's why the ERA bill talks about this 5-year term, so that it can be phased in and we can start dealing with these complex. Let's say Kusile, and you move 4,800 megawatts in a single transmission network. And the TDP is forecasting that we need, as a country, to build about 14,000 kilometers of line and about 170 new transformers. And the numbers are big, and it's important to give context to that number. So the transmission system was built around about the 70s, so it's about 50 odd years old. In 50 years, the country built 33,000 kilometers of line with some substations and capacities. In the next 7 to 10 years, we need to build an additional 50% of new infrastructure. And that's the scale of the challenge that's facing the electricity system just from a transmission perspective. So, Prof, I'll stop here.
It looks all very challenging. For the audience, Dr. Horner, who you can assume is sitting next to me, is joining us online. Dr. Horner, can you hear us? If you cannot see him, I can see you, and I think the audience can hear you. I would like to shift and ask a question, so shift topic a bit, and ask a question that relates to the just transition to you. So an energy transition involves shifting away from coal-powered fired electricity generation, but coal is South Africa's main source of electricity generation. A decarbonization agenda has serious socio and economic implications. So ensuring a just transition is a complex issue in South Africa. What lessons can we draw from the countries where you've had oversight of?
carefully on the investment costs and also how to enhance progress on setting up project pipelines. So this is something that we have to see very carefully, because the financial aspects of JET-IPs cannot be overlooked. The thesis that I'm proposing in this presentation or in this response is to say that competition policy might have a very important role in addressing the main questions raised by the JET-IP processes, particularly in the two Asia-Pacific countries I'm mentioning. The question of, will foreign investors have enough incentives to inject capital into developing countries' JET-IP procedures with a high dominance of SOEs in the energy sector, is one of the main areas that have been, of course, established and raised by these countries. There were also obstacles related to the risk and the lack of bankable projects, foreign exchange, political stability, etc. But to start with, this was an underlying process. And of course, this is an area where you will see that in this JET-IP process, there are sort of like a combination of financial instruments related to public finance, private finance, mixed forms. And I must say that what we have seen so far is that grants only constitute 2 to 3% of the financial pledges. So the lessons learned in this process is that we have to be careful on how to address the monopolistic market structures of the energy that have been allocated to few SOEs. What are the legal barriers to prevent private investment, and what is the specific state aid that has been included to boost private sector, and including, of course, SMEs incentives to go green. There's a second area that I would like to talk about, which is related to the investments, which are unfortunately in many of these sectors driven away to markets with unrestricted competition and with an overprotection of SOEs. Challenges that regulators have faced, as also has been said earlier by the fellow panelists, are related to electricity trading needs, to enable power producers to engage in direct competition. There has been also regulatory obstacles needed to comprehensive get rid of integration of renewable energy lessons. And of course, the issue of capacity and the absorptive capacity of trained staff, particularly coordination between line ministries, including for the development of the strategic plans to implement the JET-IPs. So there is, at the end of the day, a number of challenges that unfortunately regulators have been or have not been able to address it with success. In the case specifically of the Vietnamese scenario, we have seen also that the investment plan, which is sort of launched at the comprehensive and a long-term level of years for many years, have not included the justness processes. Therefore, the JET-IP processes cannot be included as part of the overall picture of the investment plan until the justness element is part of it. And in relation to this, we have seen also a fragmented approach with various government ministries, which is a very complex issue to coordinate. We have seen a sort of like a governance failure, even though there have been efforts to
shout. I hope you will hear me. Yeah. But we are apparently experiencing load shedding while discussing load shedding. So let me move back to you, Mark, and ask, in the US now, there is a recent increased interest in the electricity markets and moving towards including more of the renewable resources into the grid. But what are the lessons that we can take from how the competition authorities in the US are approaching that increased interest in integrating renewable resources into the transmission grid, when these renewable resources are often located far from the electricity demand?
Yes, so that of course is a very important issue in the United States. Obviously there's a move towards renewables and intermittent resources, things like wind, solar, renewables. And one of the problems there, of course, is that, well, there are a couple of problems. One is that it's frequently the case that wind and solar resources are located far from centers of energy consumption, and you have to get the power from the sources to the end users. The second problem is that those sources typically are intermittent in the sense that solar power is generated only when the sun is shining, wind power is generated only when the wind is blowing, and those things can occur on very short notice. So the wind can suddenly pick up, wind turbines start spinning, power starts being generated from wind turbines, and just as quickly the wind can stop and power stops flowing. And in order to ensure stability of the grid, of course, there have to be other resources that can pick up the drop in generation as a result of the wind stopping to ensure that the grid operates reliably and stably. So I'm not really an expert on those issues, but what I might talk about here is the ways in which competition authorities can advance competition in restructuring and restructured markets. The lessons here are very simple, I think, in the United States. The competition agencies in the US, the Department of Justice Antitrust Division and the Federal Trade Commission, have been very much the sole consistent advocates for competition in electricity markets. There are others involved in debates about restructuring markets who have their own particular interests. Generators have their own interests. Load-serving entities have their own interests. Generators want to keep power prices high. Load-serving entities want to keep them low. Others have other sort of distributional concerns and other concerns about sources of power. The agencies in the United States are consistent advocates for competition. And even though we're not experts in the industry, we don't know the functioning of the industry intimately the way insiders do. We don't fully understand and appreciate the ways in which wind power might affect stability of the grid. What we can do is rely on our expertise as competition analysts to articulate broad principles to guide competition in electric power markets. And we did that in the United States in the mid-1990s, in particular with respect to the formation of independent system operators. These are organizations that essentially took over the operation of the power grid from generators, operated the grid, and dispatched generation generated by generators. These are meant to be independent of the interests of generators, load-serving entities, and others. And the United States Department of Justice articulated a couple of just very generic principles to help guide the debate about how to form independent system operators. Those included things like ensuring that operation of the grid is independent of the interests of folks who are actually in the market, promoting trade across independent system operators. So in the US, there are several ISOs who are responsible for operation of the grid and dispatch of generation. We wanted to make sure that those ISOs did not become balkanized in a way that limited electricity flows from one ISO to another. So we advocated for limiting to the extent possible any barriers on the flow of electricity across ISOs. One very important reform we advocated for was the formation of market monitoring units. These are, again, independent of generators, independent of load-serving entities. Their sole function is to examine the functioning of the ISO, the operation of the transmission grid, to identify problems with market power or other inefficiencies that might arise in the operation of the grid. They're also typically empowered to propose solutions to those problems, and they frequently issue reports regarding market power in deregulated markets. So they've been a very important component of restructuring in the sense that they're on the ground assessing market power in these markets. So pre-restructuring, that was the way we advocated for competition. Of course, once restructuring came into being, we continued to enforce the antitrust laws with respect to horizontal and vertical mergers, with respect to agreements, and we continue to engage in advocacy as various issues came up. I will mention sort of our most recent advocacy effort, which is related to the issue of ensuring adequate transmission for renewables and other alternative sources of generation. And this has to do with rights of first refusal that have been granted to certain incumbent utilities in the United States. So several states in the US have enacted laws that give incumbent utilities a right of first refusal on any generation project proposed by a private developer. So a private developer comes to a utility, says, I think it would be a good idea, it would be cost justified to upgrade transmission in this certain area of your service territory. We think it would be cost justified, we think it would be good for consumers, and we'd like to undertake the project. The utility can say, thank you, but no thanks, we'll do the project ourselves. And of course, the incumbent utility has its own interests in terms of ensuring that those transmission projects get built. We advocated for doing away with those rights of first refusal, and we submitted a brief in a court case in the United States. Unfortunately, we lost that one. So in this one particular instance, rights of first refusal were upheld in ways that potentially could limit the addition of transmission to deal with upgrades that are necessary for renewables and other alternative sources of generation. Although it was a disappointment for us, our view is that you win some and you lose some. The important thing is to be a consistent, independent voice and forceful voice, an authoritative voice for competition in restructured markets.
Thank you, Mark. Let me move back to Kanye and then ask him. Can you hear me? No? I would like to move this one. I would like to move back now and maybe bring Kanye back to the conversation by asking you, Kanye, what is the Commission's response to the energy crisis?
Our response will be within the parameters of the tools we have. So firstly, we have prioritized energy as a sector, both for enforcement and for advocacy. We've also prioritized it operationally. And so when we do receive complaints that are energy related, we have drawn from the same principles that we used over COVID of rapid investigations, and we've set turnaround times for investigating those complaints that are of a shorter time frame than non-energy cases. So this is something that we've positioned ourselves for to be ready to respond in a similar way that we did over COVID. We have not, however, had the volume of complaints that we anticipated, despite our readiness. So those complaints that are on our books relate to different sources of energy. So it's not only solar panel related issues, but gas and other forms of energy. and many are still under investigation, though we have had a referral, particularly on Sasol and gas. So it is a priority for enforcement, this area of energy. The firms who are bidding are vertically integrated, and so they come with you know, the infrastructure, or rather with the equipment and the products, and also would be responsible at distribution level. But at the lower level of construction and development is where we then see partnerships with local firms. So for argument's sake, if it's a wind turbine, you know, it comes, it is imported and it's assembled by the bidder, but local players would come in at installation level, or you know, the infrastructure to erect it. And so we're seeing those kinds of mergers, mostly financing related at IPP level. And then of course, advocacy, and this is largely, it seems that it's becoming more an advocacy area, because there are all these policy developments and reforms that are underway, many draft bills that are out. So it's a wonderful opportunity for the Competition Authority to insert competition considerations to policymakers. And so we knock at everyone's door, and thankfully doors get open. So we do speak to any and everyone who is part and parcel of policy making to raise the issue, and exactly as Mark says, that we stick to our lane, kind of focusing on the competition aspects and bringing that expertise to the table where we can. Thank you.
Thank you, Kanye. Let me come back to Professor Moodley, and then perhaps ask localization of technology components as energy markets evolve and become more competitive.
Absolutely. What we're seeing is that, you know, I talked a little bit about the scale, and maybe just to reiterate, over the next planning period, the next 10 years, we essentially as a country going to double the source of generation. So we're going to add, we currently have about 54 gigawatts, we can add another 50 gigawatts of generation capacity in the wholesale market over the next decade. And that's massive, that's a massive opportunity. The same thing with transmission, we're adding 50% more transmission lines and transmission substations in the country. And the question is, we need to learn about our past, and we need to bring that into our future decision making. And the point being is that you don't have to manufacture everything, but you need to start somewhere, and you need to take opportunities where they come. They might be just inverter technologies and so forth, but you have to start somewhere. And that's kind of part of the challenge around the justness of this energy transition. What we are doing as a country is displacing many highly skilled jobs, engineering skilled jobs, and we're displacing it with very basic skills. And we, as a country, talking about we're creating job opportunities, and we're really not. So that's very important. I think the other big thing is that most of the world, the entire globe, has already committed to some sort of commitment around net zero. Which means as much as South Africa has this big challenge to build up the generation capacity and the transmission capacity and even the distribution capacity, most other jurisdictions across the whole world has the same challenges. And ultimately, from a supply chain perspective, when you are competing and bidding for a transformer or a wind generator or a solar panel or an inverter, you are going behind the queue. And what we've seen is their own manufacturing capabilities. They've been able to transition very, very fast at very little risk to the economy, whilst creating jobs and creating economic activity. So it's something that we need to, as a country, talk through and get through. But we also need, you know, kind of the policy and the regulation and even the competition aspects to come through. So from a policy perspective, you know, recently we had the, the, well, just to choose my words wisely, we've taken out all of the red tape for homeowners, commercial enterprises, industry to put up rooftop PV. We've given incentives for a short period of time, but does that create certainty for local manufacture if the incentives are only for the next 12 months or 24 months? And I think we need to take those learnings and feed it back into policy, regulation, and then also the competition aspects. I think beyond that, it's also just be aware that it's very easy to regulate a public monopoly because the objective is for the public good. It's very different to manage and regulate private industries that has these tendencies to go to oligopolies and so forth, and we've seen that some of that in the IPP space. And my basic theory of economics is that you want this infinite competition, and you get the prices being set at the best efficient level. We're not there, right? We're starting off from a monopoly, and we've got a journey to go towards ideal competition. And through this journey, we have to manage all of the new entrants and the practices and so forth. And it's certainly different types of regulations, different types of activities, and until we get to this ideal state. So I think very important how we manage this transition, how do we set policy, regulation, competition during this journey, and how do we make sure that through this transition, these opportunities are being realized locally, and we take away country risks.
Thank you, Professor Motley. Dr. Horner, if I can, thank you, Professor Motley. Dr. Horner, if I can come back to you, perhaps ask you the question that relates to the disruption that's caused by the transitioning away from traditional industry, so moving away from coal-powered electricity. That can be an obstacle to transitioning successfully. What lessons can we learn from your observations about how others are doing it?
Yes. Can you hear me?
Yes, we can.
Thank you. Yes, I'm not sure whether on the last question you posed me, whether I could be able to express the last point of my presentation related to the just energy transition processes. Indeed, if we look at the lessons learned from the global observations, particularly in the Asia-Pacific region, I made a small comparative assessment on this just energy transition process. I hope you can see it in the screen. I'm sharing my screen. You can see, for instance, the jet IPs processes in Vietnam, Indonesia, even though it's not a access in Colombia, but it's also another process that is being there. This has been something that we have been looking at these observations in specifically. There has been also, as said earlier, some issues related to fragmentations of JETPs across several ministries in these two countries. We have also seen, unfortunately, some issues related to policy documents in Vietnam or Indonesia, of little mention of the JETP processing itself in the mainstream policy making. I must say that recently, when I was in Jakarta, we presented these processes to the Competition Commission of Indonesia. We invited the other line ministers in charge of the JET-IP processes in that country. And what I could see immediately is that the Competition Commission of Indonesia was not invited to participate in the meetings for the planning and implementation of these investment plans and resource mobilization plans. They have not been invited, and also it must to fair justice as well. The Competition Commission have not seen that process as important have not seen this process at least at the inception phase, that their interaction or their participation can actually be meaningful at this stage. But if we look at what we have seen so far in the lessons learned on these processes, even though it might be some premature to say that because in the case of Vietnam and Indonesia, they're still looking at the investment plan and the resource mobilization plan, but we can already see that there is a lot of areas where there is issues that would be very difficult to negotiate justice elements, particularly in the case of Indonesia, because they are subsidizing livelihoods for a non-limited period. So there is a lot of politicized issues that we should be able to avoid in this particular process. A sort of issues that we have seen, particularly in the area of boosting these processes in the next level, beyond the national level, but to a regional level. You've seen in the case of the African region, I just been object of a power shortage when I was talking about this topic earlier, but there is a possibility, or there are some ideas and voices that we should be able to look at it, because when it comes to these processes of just energy transition process and its potential role of competition, as I said at the beginning of my reflections, it is not about, it is actually addressing the problem of the just energy transition, at the same time correcting the market failures for the transition itself. So we cannot underestimate the role of competition authorities and competition policy making in this process. We have actually seen that this was the main problem in countries that we wanted to do so, even without the JIP process. I mentioned earlier the case of Colombia in Latin America. So in terms of the way forward for this particular area, we have seen that there is an underlying need for a regional level political willingness to move away from big projects, power projects. We should be able to see, for instance, centralized electricity productions and a heavy reliance on coal can actually be focusing more on a decentralized, community-based, community-owned local solar projects, particularly in the key areas and the key green pipelines that are being discussed in these resource mobilization plans. And for example, discussed in the case of Vietnam. So this is one important area. The second part is the institutional coordination. And that is something that we need to make sure that is not only about the line ministry, which is already sort of a problem in itself, but also coordinating among other countries that are experiencing the same processes. We have seen that on the issue of the leverage existing funding to countries to attract sustainable and green financing opportunities, for instance, in the case of carbon emissions trading and green bonds, we should be able to see how this leverage funding can actually be attracting these countries that have not only mitigation but adaptation costs for the high carbon risks strategies. And that's something that we have seen also in the processes of the JETPs or JIPs in general, that it is just a boost because they also are part of an overall picture of just energy transition processes. And we have seen in the case of these two Asia Pacific countries that, that they are struggling currently on this. The bulk of the financial pledges, as I said earlier, to transform it into concrete project financial deals is one of the main concerns of these two countries. And unfortunately, because the JRP process have an interaction of not only government or public finance operators or stakeholders, but also private finance stakeholders, they also includes what we call the IPG members, the International Partner Group members, that also need to come together in order to make sure that there is coherence. Because at the end of the day, as I learned from my recent visit to Hanoi, officers at the Ministry of Energy are worried about whether or not this is going to be another additional debt trap. This is already happening, or at least it's being voiced in Indonesia in the press currently. So these are areas in which I would like to highlight to the audience how competition policy can facilitate the just energy transition processes in a concrete way, right at the outset of the analysis, and not to be at the peripheral acting scenario where other ministries and other specific key stakeholders might underestimate the role of competition policy and the role of competition authorities for that matter. Thank you.
Thank you, Dr. Horner. We've come to the end of our discussion, but let me just invite Professor Motley, Kanye, and Mark for any concluding remarks.
Absolutely, thanks, Prof. I think it's an interesting transition. It's going to take a few years. I think importantly, as a country, we committed to net zero by 2050 and not today. So the transition is at least another 27 years. We are changing the energy industry environment, and through that, there's this massive opportunity to create growth, create economic activity, and reindustrialize as a country.
Yeah, I mean, if we're talking timing, we are in this for the long haul. You know, whatever policy options government moves forward with, eventually, what is very clear is that to have, you know, security of supply that we need in a sustainable manner, you know, is some time away. Even the processes related to governance in this regard are some time away. So I think for ourselves as competition authorities, we would have to be patient and consistent in advising government and engaging with government and contributing with our resources, whilst at the same time being responsive to the evolving market dynamics, because it is a regulated market, and of course policy is central, policy and regulation is central to it all. But we know that consumers and businesses, you know, do innovate and find ways around these short-term solutions. And so from a competition authority perspective, these are you know, dynamics that we would remain responsive to then in the interim. Thank you.
Thank you.
Well, as competition authorities coming to an incredibly complicated industry, it can be daunting to try to think through the technical, the economic, in the case of South Africa, the social issues involved in electricity restructuring. And there may be a tendency to throw up your hands and say, we'll never understand this, we'll never figure out competition, maybe we'll just leave it to the traditional regulator to sort out how to implement restructuring. I think that would be a mistake. As competition authorities, we have really sort of a very valuable role in this, and that's to ensure that competition principles are observed in a way that results in markets that produce the lowest prices possible for consumers. As I said, the mistakes, the consequences of making mistakes in restructuring that might yield uncompetitive markets can be enormous in terms of the cost imposed on consumers. So I think it pays to be persistent. I think it pays to develop the expertise needed to fully understand competition in these markets. and I think it pays to be a forceful advocate for competition despite the incredibly complex issues you're dealing with.
Thank you. Let me end by thanking our panelists who've contributed their time, their expertise, their talents so generously to us. Thank you for your participation. Thank you for listening. I think it's time to go for lunch. I'll hand over to Offense, but thank you for your time.
Thank you very much, Liberty. Our seats and get ready. It's another after lunch session, but we are talking all things health and the NHI. So I feel it's a topic that each and every single person sitting here is really keen to hear about. So this is plenary session number 5. And as I've already said, it is going to talk about the path to the NHI. And I mean, there has been much debate, around the NHI, its implementation, what it's going to mean for medical aid schemes and medical service providers more broadly. And there's definitely no doubt that the implementation of the NHI will change the competition dynamics in the market. Of course, it will remain critical to ensure that these markets remain competitive, in order to make sure that the NHI is successful in its implementation. And so today's panel really will look at some of the areas of concern or potential areas of concern that competition authorities need to focus on in order to ensure that, that the implementation of the NHI is successful. The panel will be moderated by Mapato Ramokgopa. Mapato is a divisional manager in the Market Conduct Division at the Competition Commission. And on the panel, I'm going to start from my far right. We have Dr. Rajesh Patel, who's registered with the Health Profession Council of South Africa. Next to him, we've got Dr. Ntutuko Bengu, who has been a medical practitioner and anesthetist since 1991. And then next to him, we have Dr. Sipho Kabane, who is a CEO or registrar in the regulation of medical scheme industry in South Africa. And then joining us online is Fatima Hassan. Fatima is a human rights lawyer and social justice activist and the founder of Health Justice Initiative. Mapato, I'm going to hand over to you. Hi, Fatima, we can see you online there. Hope you can still hear us. Thank you, perfect. Mapato, I'm going to hand over to you and your panel. Thank you.
Thank you very much, Karabo. Good afternoon, everyone, and a warm welcome to my panel. It's an honor to have you here. Today, at least I'm sitting on the other side. I'm the one that's asking the questions today, but I'm looking forward to a fruitful conversation. I mean, as Karabo has mentioned, the NHI is here, and my role here really is just to discuss with you panel members how we can ensure a smooth transition towards universal health coverage. And the conversation is not really about whether the NHI is a good policy or not, but the conversation should progress to a point where we can enable a smooth transition towards that, and what would be the role of competition policy in that transition process. So I'll start with you, Dr. Kabane. How can we transition from the current health system to the NHI? What are the core principles of this transition process? And given the fact that you've worked with medical schemes in a regulatory space, but also interacted with the Commission a lot in our work, what do you think in that transition process should be the role of competition policy?
Yeah, thanks, Mapato. You mentioned a very important word, that the transition should be as smooth. And I just wanted to add to that, that it should be as risk-free as possible. Just in terms of the principles that we think are important from a regulatory perspective, is that we need to ensure that in that transition, the scheme members are protected and their interests. And just to expand on these interests here, we still need to make sure that if you're a scheme member, you get the quality health care, that you deserve. We also need to ensure that there's financial risk protection. In other words, you don't become impoverished because of expenditures that you cannot, manage. But we also want to make sure that the assets of the schemes are protected from fraud, waste, and abuse. And we want to make sure that in this transition, all those entities that are regulated by us, continue to comply not only with the Medical Schemes Act and regulations, but with all other legislations, including competition law. So for us, it's very important here that the presence of the competition law within that transition actually assumes a balance here, between over-enforcing and under-enforcing. Because we know historically, we come from a situation where price negotiation was seen to be collusive, and it has created a huge lacuna in terms of, determining what is fair and what should be charged for services and goods within the space here. But we believe that the competition law needs to be applied as it is being applied, and it needs to make sure that competition is promoted and that anti-competitive practices are dealt with effectively.
Thank you, Dr. Kabane. I'd hoped to hear from Dr. Nicholas Crisp, especially around the application of competition law on the NHI, because earlier versions of the NHI had excluded competition policy from application to the fund. But the latest iteration does mention that only the fund would be exempted, meaning that perhaps transactions entered into with a player's competition policy would apply. It leads me to my next question, and I'll address that question to Dr. Patel. NHI is expected to purchase services from various sectors of the health system, so that would include private sector players as well. How do you think that purchasing and contracting agreements should be structured, balancing the interests of the fund itself, sustainability of the sector, but also protecting consumers? And I ask this because you have a lot of experience in the medical schemes sector as a funder. Thanks.
Is this working? Yeah.
Yeah.
Thanks for the question. I think it's a pertinent question. We were involved with the whole NHF process from 2009. If you look at the green paper, there's a section of about 3 pages on how you would remunerate providers of service. That's literally the input that BHF made into that process at the Ministerial Advisory Committee. So I think, yes, you're absolutely right. The funding industry has got some experience at contracting with providers. To some extent, in certain areas, it's been successful. In other areas, not that successful because of the distribution of providers that you have out there, and to some extent, the kind of power that they might have and funders have at certain times. I also think there's been some problems in our environment, largely because of the intervention of the Competition Commission in 2003, 2004 period. But we can go into the details of the whole thing. The big issue at this point in time is if you're having regulated benefits, you need to have a regulated pricing system in place. so that you can procure those benefits. You can't have the current scenario, and you can't have the scenario like our regulator has the interpretation of Regulation 8, where if whatever the provider charge means that's what must be paid, even if it's relevant or not relevant. You can go into those debates. So contracting becomes absolutely important. The first hurdle, if you read the bill, is to contract with providers, they need to go through a couple of steps before they can get the contract. And if you read that component, I think there's about 4 or 5 steps. There's one component that's missing there, which perhaps maybe we can make it public now, is if you want to contract with any state entity, and this is in the Public Finance Management Act, is that you then need to list with the Treasury as a service provider. So that component is missing. If I put myself in the shoes of a GP or anyone, I don't know what this contracting process and this accreditation process is going to cost me, for starters. There has to be a cost to that accreditation. So who's going to pay for that? What is that cost? Secondly, before I even want to initiate in going into any of this kind of contracting arrangement, is what is the contract going to look like, and how much am I going to get paid for whatever service I'm going to. So if I'm a GP and you're going to get involved in risk-based capitation, well, what does that mean, given the risk of patients that I'm currently treating? And once I know that and I'm comfortable what's going to be in that endpoint, that's the only time I'm going to start the whole process of getting involved. One of the problems in this bill says that people, if they want to join the NHI as members and become users, you will register at a service provider. Sounds a little contradictory, because if you want to become a member of medical scheme, you register with the scheme, not with the service provider type of thing. But in any case, to register with the NHI, you have to do it through a service provider who's accredited. Now, if you've got this kind of complicated process to go through, how are you going to get people on board? So you have that kind of pricing issues, that people are not going to contract unless they know the process and the certainty of the process. And if they do contract, the content of that. And I don't think there's sufficient information at this point in time as to where that situation is. I know they probably do more research, etc. It's taken me a couple of years in the late 90s, early 2000s to fully understand how you should implement something like risk-based capital. It's taken a while to understand things like diagnosis-related groups, and how you would even do the analytics related to that, how you would link up quality to that. Because at the end of the day, service is not just about the price for that service. The question is the value that you get out of it. So it's not just contracting like we've done in the medical schemes, which are price contracts. You need to build into the equation the whole value component. And really is what Dr. Kaban has talked about, is that quality. Are we comfortable with the state's capacity to assess quality? I'm in this industry for almost 30 years. I've been doing quality assessments from the day I entered this place to now, and I can do quality figures left, right, and center. I'm convinced at this point in time, any of our government agencies or regulators who are supposed to protect the public have got any access or are doing any kind of quality assessment at this point in time. So how are you going to match remuneration with that quality? And really, in reality, the contracting should be on the basis of the quality delivered. Yes, there's going to be accreditation, but is the accreditation a tick box of what you have in your rooms, or is it going to be included with that the quality delivery that takes place in that service practice? So yes, it might start off in the process of saying, let's see if you're a GP, do you have an ECG machine? Do you have this equipment, that equipment? Do you have a bathroom where people can collect urine specimens tested, etc.? So it could be a tick box. You have to collect data to get there. If you're going to start with value-based contracting from day one, are you going to use data from the industry, funder industry, to get to that point? So, Dr. Crisp is here. So there's a lot of things that need to be done, and I think before we even start contracting public sector, private sector, a lot more details need to come through as to what it's going to entail, etc. And start off is the benefits as well, because you're only going to contract with service providers that would potentially be related to those benefits that are on offer.
Thank you for those thoughts, Rajesh. I'm picking up a theme. Oh, sorry.
Sorry to interrupt. I thought it was important that I take this moment to welcome Professor Nicholas Crisp to the panel. He is part of the panel. Professor Crisp is a medical doctor and public health specialist and honorary professor in the public health medicine at the University of Pretoria. Thank you very much for joining the panel.
Thank you, Karabo. Welcome, Dr. Crisp. So I'm going to go back. The first question was actually for you, so I'm going to go back to the...
Yeah, the speaker's back. The first question is for you.
Okay, I can't hear you. Sorry.
Is my mic not working?
Yeah, I can't hear.
No, I think the speakers are directed that way, so we can't hear this side.
All right.
I'll try.
You'll try.
Yeah, sorry I'm late. I'm not familiar with Joburg, and the traffic took me to a completely different place. So it took me a while to find my way back again. Anyway, thanks.
Yeah, maybe come this side.
Then it comes.
Yeah.
Sorry.
All right. Dr. Crisp, the first question related to the process towards the NHI. How can we ensure that we transition from the current system to the NHI? And what are the core principles of this transition? And what would be the role of competition policy in this regard? And I say this as well, you would remember that the first version of the NHI had excluded a competition law from application to the NHI, but the latest version talks about only the fund being exempted. So maybe when you clarify the role of competition policy, just guide us on how the fund will apply and where should competition policy be applicable. Thank you.
Okay, thanks very much. And once again, apologies for being late. So you're quite right. The clause that deals with competition was changed during the Portfolio Committee hearing in the National Assembly. Originally, the clause said that the entire, everything to do with NHI, all transactions would be exempt from the Competitions Act. The debates during the line by line, and we don't participate as the department, it was just the members of the Portfolio Committee. In that discussion, they said the intention was never to exclude everything, but it's to make sure that the fund itself is excluded. And that's because of the way in which the fund is set up to contract from all providers, not going to go on tender. And it's not looking for price competition because the fund is going to set the prices, but what it's looking for is competition on the basis of quality, in other words, outcomes. So the focus will be on outcomes measurement. So let's go to the other part of the question, which is the transition. So the media seems to have created, and I think sometimes it's deliberate, people who speak in media spaces, created the impression that the NHI will be switched on this year or next year. And therefore the economy is too bad, we can't do it, and this doesn't work and that doesn't work. But if you read the bill, there's no intention to switch the NHI on next year or even the year after, or even the year after that. Section 57 of the bill deals with transitional provisions. And it is now, that was also amended during the Portfolio Committee hearings, and it now has two phases. Phase one starts in this year, so it's anticipated the bill will be passed by Parliament in November. We're a month away. And in fact, we're busy with hearings at the moment in all the provinces. So it's envisaged that once the bill is assented to by the President, then it will be brought into effect one clause at a time as the clauses are needed in order to meet the expectations of Section 57, the transitional provisions. So what it says in Section 57 is about phase one, is it will be a 3-year period for the development of the legislation required to run the fund and to put the administrative processes in place. So clearly there's no law now, there's no board, there are no board committees, there's no chairperson, there's no CEO, there are no staff, there's nothing. It's a shell. In fact, I've got a staff of about 60 people, and most of them work on product procurement, because that's what they were doing in the department before they came into my branch.
Up until a month ago, it was really just one other person and myself as full-time employees in the branch. We now have another 16 people, and a couple more starting in next month. You clearly can't run a fund on 16 or 17 or even 100 people of this size. So Section 57 allows for the creation of that entity. There will need to be regulations published about the board. It will have to clarify how the board is appointed, how the minister will appoint the ad hoc panel, what will be the requirements of the members of the ad hoc panel, how will, the bill says that they will interview in a transparent manner. What does that mean? Now to us, that means something very, very transparent, but to others it might not. So we will draft the regulations once the bill is assented to and that clause is brought into effect. We publish it for 3 months for comment, incorporate the comments, and then set about the process of putting the governance structures in place. So I envisage just to get the board and the committees will take at least 9 months, if not 12 months. So it's going to take a process.
Thank you very much, Dr. Crisp. Fatima, I want to come to you, and there's several themes that are coming out from the responses that we've received so far. There was a talk about a risk-free transition, ensuring that we don't have cumbersome onboarding processes. There must be a value component to it. And Dr. Crisp just spoke about outcomes monitoring as well. I want to check with you, Fatima, especially your experience in the health justice space. How can we ensure that the fund creates value for ordinary citizens? How can we ensure that the fund protects the rights of ordinary citizens? Thanks.
Thank you. So I'm assuming you can hear me, right? And that the sound is fine?
Yes, I can hear you.
Okay, great. Because I'm not able to see you, so I'm just going to speak and hopefully you can see and hear me as well. So I think the starting point for us, and I know that different speakers have focused on different topics, the starting point for us is that however long it takes or however short it takes for universal health coverage through national health insurance in South Africa, our particular focus is on access to medicines, and we want a fair, unambiguous, single, transparent pricing system. And so there's a particular role for competition law and competition policy in that space because of the reality that the NHI, whatever bill is finally adopted, with whatever amendments in the next few months or even before the national elections, is operating alongside the Competition Act, it's operating alongside the Constitution, and it's operating alongside, unfortunately, a very outdated set of patent laws in our country. And so however the NHI is going to operate, and we can come to the role of the Health Products Procurement Unit, the Benefits Advisory Committee, the Benefits Pricing Committee, there's multiple committees and units that are proposed under the NHI. However that operates, I think we have to sort of really grapple with the reality that we sort of dealing with, and that's the market reality of very powerful, set of players, particularly in the pharmaceutical industry, that basically are the difference between often life and death choices and decisions, where manufacturing is quite concentrated and where pricing is often very non-transparent. So the regulatory space, I think, for regulating the prices of whether it's going to be medicines offered to the NHI fund or medicines offered to other providers in parallel to the NHI fund while this transition takes place, I think is going to be important. Because remember, our understanding of the B bill is that it actually, for a while at least, creates 4 different systems for people to access medicines in South Africa. And over time, you may only be able to access it through the NHI, but the bill does have provisions that up until the medical schemes, industry is transformed and the minister issues a certain determination that's dealt with in Section 33 of the bill, basically medical schemes members will continue to be able to access medicines from that particular system, and then everybody else who doesn't belong to a medical scheme or who's not regarded as an NHI user, because there actually are exclusions, in the bill will have to basically procure medicines out of pocket, including people with visas who are, international students or international workers. So where we see the entry points, and assuming the process issues, the transition issues, the legal challenges are all addressed and sorted. But where we see the entry points for competition law and policy, and I think it's really significant that about 2 weeks ago, the Competition Commission announced a really groundbreaking investigation into a very well-known pharmaceutical company, not just on its price for a particular and very important TB drug, but also for its patenting strategy, what we call evergreening conduct. And I think that hopefully can set the precedent for the type of work the Commission is going to have to do under NHI in whatever phase of the NHI we will be in for the next sort of 5, 10, 15, 20 years. And there's 4 elements to that. I think the price gouging and the excessive pricing inquiries would have to continue. I think the exclusionary conduct around evergreening has to continue, and then abuse of dominance. And I think the abuse of dominance is really significant because if the NHI fund over time becomes the sole procurer, the way the bill is drafted, it talks about being the sole procurer, single purchaser, single payer for all NHI medicines, then the price that the different parties would charge within that process and how and who is going to negotiate with multinational pharmaceutical companies, I think is going to be significant. I think the big question mark is what is going to happen under the system to medicines that fall outside of the NHI system, because there is provision for top-ups, there is provision for offering complementary products and services if the state is not going to provide a particular set of benefits or a particular set of medicines. So what happens to the single exit pricing system in this country? What happens to the pricing committee? Are we going to have a separate pricing committee for non-NHI medicines? So I think there's a lot of questions that still need to be asked, but while all of those issues are being resolved, I think there's definitely a place for competition enforcement and policy. Concern that we have, obviously, as civil society is how we're going to interpret Section 3.5, which is sort of the new provision around exempting the fund from the Act, but not exempting, all the other transactions. Maybe we can talk about that later in the discussion. Thanks.
Thank you, Fatima, for that. Dr. Bengu, you worked on the HMI, and they made several findings on the functioning of the private sector, market power on the provider side, overutilization of services, importantly, the lack of a tariff determination mechanism. Why do you think these are important as we transition to the NHI?
Can you hear me? Okay. Yeah, thank you very much. Good afternoon, everyone. Yeah, I think I'll answer in a sort of roundabout way, but you will see the relevance. The NHI bill came out between the time we had published the interim report and the final report. And one of the questions we found ourselves frequently had to answer was, is the HMI report still relevant, given the NHI bill? I suppose we were surprised it was a frequent question because in our minds, obviously working with the department, the Competition Commission, it was really, we didn't see this, it was always about preparing for a version of universal health coverage. So we never found ourselves defending recommendations that were not aligned to universal coverage. Just look at this. I always say the best way to analyze universal health coverage is to look at it in 3 parts. The first part is obviously what you have to do, the raising of funds, the pooling of funds, the service delivery. And the second part is the intermediate objectives, but the critical final objectives, there are 3 main ones. One is making sure there is access to health services based on need, not on affordability. The second one is that those services must be of good quality. The third part is that people must be protected from financial ruin, meaning the service must be affordable, reasonably priced. Now, if you look at that, the little I understand of competition law is basically that without competition, pricing is always likely to be higher than it needs to be, and quality is likely to be less than it should be. You are already seeing 2 of the 3 main objectives I was referring to in terms of universal health coverage. And actually the third one of access is going to be covered if the pricing is right. So for me, there's complete alignment in terms of competition law and universal health coverage. That's why there was never going to be a situation where there is no alignment. Now, in terms of what the way of getting around the issue whether it's not relevant, it was always going to be a transition, hoping that there would be implementation. And if one looks at the main categories, there are many recommendations, but I'd say it's 4 main categories. Because even if you look at the much controversial supply side regulator for health, there are 4 parts there which are relevant, and maybe that's where the focus should be. What is it we're trying to solve? One is the planning of healthcare services, the main part being that the licensing process seems to be not working, hospital licensing in particular. The second part is the pricing of healthcare services. We didn't have it then, and we don't have it now. And I really think if there is one thing that needs to be sorted, it's this one. But also then the monitoring of quality, which Dr. Crisp has already spoken about. And then the economic valuation assessment. Now, that's just one component around the SSRH. Dr. Kabane at CMS, a few weeks or maybe months ago, there was a circular around health technology assessment, which would have been economic valuation of economic. A consumer leaves home potentially not knowing what they're going to pay. And the inquiry showed how that on its own drives higher prices. And I really do hope that the department is focusing on this, because once you get that, at the very least, the NHI, it would almost be a laboratory, if you like, on pricing of healthcare services. In terms of how it was recommended, it's the same players. The NHI fund will be purchasing from the private sector, and this is what the pricing framework is about, mainly dealing with the private sector. The main advantage will obviously come when you are looking at multiple funds versus a single payer. But the framework would be in place. That to me is another example of just how the alignment, how implementation of the HMI recommendations would actually help us on the path to a successful implementation of NHI. The other issues that relate to practitioners, the HPCSA has started dealing with the issues that we believed were in the way of multidisciplinary healthcare services. And that's also, it's the same practitioners that are seeing patients now that would be seeing NHI fund sort of users. And the same thing, the funding side, we know that its participation is controversial, but it's very clear, it was very clear in our minds as the panel that the issue of starting to come up with products that simplify funding is critical. I'm not sure how well the industry has responded to that. I do know that, for example, James had made that one of their objectives to simplify the structure. And all of that speaks to ultimately what you would want to see in an NHI environment. So there's never been any doubt that what the health market inquiry found and recommended is not only aligned with the ultimate principles of universal health coverage, but it would help bring about a system that's been tested in some ways. So I think that's my view of it.
Thank you, Dr. Bengu. Dr. Crisp, what has been done? It's been almost 4 years that the recommendations were made. What progress has been made? I'm more interested in the urgent issue that was highlighted, and it came out also in the conversation around tariff determination.
Yeah, thanks very much. So yeah, it's been 4 linear years, but only 2 years because we lost 2 years because of COVID. Some of you might have got to know my face a lot during COVID. So I did nothing else other than COVID, and we were not really able to do anything. All our resources were diverted to COVID for basically 2 years. Prior to COVID, we had already prepared a response. We'd given it to the minister, and as you all know, I've had 3 ministers of health since I've been in the department for 2 years, in the first 2 years. That was also disruptive, and we've had to pick up a second time. But we, at the moment, and there are a number of things, concrete things that are happening. Number one, I agree with Dr. Bengu's comments. A lot of what is proposed in the health market inquiry is in fact things that we are doing and agree with. The route to get there is different because they were operating, as he said, in a void without the bill. So recommending a Schedule 3A entity as the supply side regulator was legitimate at that point, but now we are creating a Schedule 3A entity for NHI. You won't be able to have both of them. The second point around that is that we have prepared extensive documents to the national minister on private hospital licensing, in fact, all hospital licensing. And since I've been around in the system 40 years, yeah, it's 40 years this year, I was involved in implementation of Section 44 of Health Act 63 of 1977, which is what is currently still being used by provinces to justify their licensing processes. Now, we are busy with a legal opinion on that. I do not believe they have any mandate or any right to be doing licensing anyway, and it should always have been in the national department. So we agree we need that to be in the national sphere, and it needs to be done in a comprehensive way, and they've laid out in the report quite a lot of detail about how to go about it. In terms of simplifying what happens in the private insurance space, private medical scheme space, we've been doing a lot of work with CMS over the last while, and there are a number of parallel things that need to be taken at the same time. And where they aim to is the recommendation in the health market inquiry to have one compulsory common package that everybody has to provide that is identifiable and the public know what they're dealing with, and we can price it appropriately. I'll come to the pricing in a moment. Now, to do that, we've had to go and wait for the work that CMS is doing on the review of the PMBs, because some of that impacts on this process. We've had to take part of that PMB process and integrate it with the review of the public sector's primary healthcare package. And we've had to look at the intentions of this combined package. But further to that is that where the NHI is going is no fee for service. So this highly itemized set of billing codes that is in the current private sector is not appropriate for where we want to go, and it's not what you want to do in an integrated package. And so we've also had discussion with some of the medical schemes. James was referred to, so obviously we speak to James quite a bit as well. And where we are going is to use capitation payment. I think everyone knows that's what's said in the bill. But we have a complicated service delivery framework, not just because it's public and private, but from highly urbanized to peripheral urbanized to rural to deep rural. The circumstances are very different. Some is entirely public, some is entirely private, and then there's quite a lot of mix between public and private providers in different parts of the country. So how does one bring the multidisciplinary team together and pay capitation so that there's a constant revenue stream to the providers in that space, but there's also reward for outcomes improvement, et cetera, et cetera. And how do you define that package? So we have prepared an internal document. It's still got to be consulted in the departments of health, and then we'll go for wider consultation on the capitation framework, how it will work, how its structures are intended to be evolved over time, because we won't start with all primary healthcare providers in the beginning. And then what is the package of care that can be provided inside that that's uncomplicated and could form the basis of the initial package. Then I'm not going to talk about the OMRO and so on, because again, the principle is agreed to. There are already agencies in both the public and the private space that deal with or have done a lot of work on outcomes measurement, and we like what we see. The question is how we bring that into the space and whether it goes into the Office of Health Standards Compliance or into the NHI Fund or in the department, and there are pros and cons of all of those. So we are in agreement with a lot of the work. There's been quite a bit of consultation and thinking through the various steps, and we've prepared a comprehensive document for the now Minister of Health. And in fact, just last week, I said to him, hey, we need a whole day to sit down and go through. It's 177 rows for the 56 recommendations. Some of them are just straightforward yes, 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 or no, no. But there are a few of them that are not about whether to, it's how to. And how we do that in the context of what we want to do with NHI. So that's that space. I'll hope you'll ask me to respond to Fatima's questions just now too.
Yes, I'll give you an opportunity. Dr. Kabani, some of the recommendations were targeted at the CMS to enable some changes. I just want to get your perspective in terms of the progress that has been made and how, whatever work that may have happened could assist us in the transition towards the NHI.
Yeah, thank you for that question. Indeed, some of those recommendations were directed at the CMS. And CMS has started a number of processes that are expected to address those recommendations. For instance, one of the recommendations talked about this single, basic options across all schemes. We've done extensive technical work around that because we believe that that could be an entry point also into the NHI package. But in terms of how do we now, migrate or convince all the schemes to actually buy into that, is that if you look at the process that has been followed through the prescribed minimum benefit review, we see that process basically converging into the single option across all schemes. Because as you review the PMBs as they currently stand, and you introduce a primary healthcare element to it, indeed, as you resize costs and make it affordable, you might actually end up with that single option. And we are also of the view that this is going to be a consultative process. We won't just sit in a corner and come up with this option. But I think the current process that we're engaging in the review, where we're doing the costing, the affordability, the willingness to pay, once that process is completed, we'll come with numbers but are absent, would be part of that. But we appreciate that once you've got that single option that everybody understands, then, you know, for the first time, at least the consumers of the options will have a fairly good sense of what sits inside that benefit option. Because currently with these multiple options that exist, it's very difficult to make a rational choice. So we agree with the HMI, you know, on that score. And we think it's important to advance that work.
Thank you, Dr. Kabani. I want to ask Dr. Patel, I'll go back to Hasim and the questions that she asked. I want to know from you, having been part of the COVID response as funders, what lessons can you take from the way we responded to the COVID pandemic, and how can we translate those lessons into the NHI process?
Didn't hear the question.
My question is, you were involved in the COVID response.
And the?
COVID,
yes.
Yes. So what lessons have been learned from that process, and how can we take those lessons to try and assist the transition towards the NHI?
Fantastic question. I think COVID taught us a lot, and I hope that there is some lessons that people learned out of it can be put in implementation. So firstly, I want to actually compliment the Minister of Trade and Industry, who's in charge of Competition Commission as well, for the exemption, and he produced it very quickly, just at the early onset. It's unfortunate that my colleagues sitting on either side representing the institutions didn't take up that opportunity or implement it during the COVID period. Very unfortunate, so we missed a big opportunity to try and work with suppliers in that regard. One of the successful things that took place during COVID is the whole public-private partnership issue in addressing a burden in the nation. And I think, you know, if you can do it well with COVID, where public and private could work together so well, I think we can definitely make something like NHI if we work in a collaborative way to actually get that as a successful launch, and successful implementation. I think the lessons need to be, what are the things that went wrong? So definitely when it comes to implementing COVID, the negotiation issues and the contracting issues, for example, there was an alternate reimbursement model that was presented for hospital admissions. Unfortunately, it looks like only one province was able to receive bills. None of the other provinces were able to even receive it. That province that was able to receive it, I don't think there was any take-up in terms of people being admitted to the private sector and bills being submitted. If they were, you could probably count it on one hand. So the question that we need to ask is, there was urgent need for facilities. Yes, even the private sector facilities were full, but what went wrong? I think in the production of that alternate reimbursement system, there wasn't collaboration, there wasn't engagement with the service provider. So if you want to engage a service provider and contract with that provider, you have to sit around the table, together come up with a formula of how you're going to determine values, et cetera, and how you're going to determine that structure. I don't think that was done. And I think that's a critical step, is engagement with that provider. I know Nicholas can tell us what happened in the background, because I'm just looking at it from one direction. Okay. So to me, that was an issue. I know that when it came to that administration fee, we were sitting in some of the meetings with the various providers and knowing what they wanted. My colleague out there and myself, we were considered as difficult guys because we weren't agreeing to what they wanted. And fortunately, in the end, Department of Health ruled what they wanted to put in place, and literally everyone became losers in the process there. And in fact, if only the guys were pragmatic at that point in time, we could have presented something on the table that would have been acceptable to almost all the parties. So it occurred on both sides. On the one hand, the guys wanted too much, and obviously from the government side, you could understand, and I even could sit back and say, you know what, I would never even accept that kind of thing in a scheme environment. So if I'm negotiating on behalf of schemes, I would never accept that type of value. So there was that lack of pragmatism and a kind of excessive demand side from the service providers. And I think that is part of the problem we're facing in the healthcare system, and there needs to be lessons out of it, is this whole thing of when you have an opportunity, try and grab as much as you can. I think the opportunity is take your small margins, but you'll make your margin to survive. They're not looking at it as, if I get a reasonable price and I start seeing more patients, I can actually make more money. But also, when we talk about the quality and value, at this point in time, for hypertension and cardiac diseases, only 20 to 30% of those patients get an ECG done. If I'm a GP, if I do an ECG, I'm going to earn extra. Why aren't the guys actually doing that type of intervention? They're getting quality plus earning revenue in the whole process as well. So there's the quality component in which they can earn. It becomes a win-win. You win on the quality, etc. And it's critical, and I'd really like to see some of the things that has put in place in the department in measuring quality. So I'd really like to see that. I'd really like to start implementing a lot of those things in the private sector right now, so that when Nicholas is ready in 3 to 4 years' time, we can have service providers primed, ready to be able to contract immediately and deliver the care that we need. We don't need to wait and start 4 years and start looking at, oh, here's a quality problem, what are we going to do to fix it? We can use a lot of the piloting right now in the scheme environment. Providers are ready, funders are ready to even pilot a lot of those programs that Nicholas has in mind. And I think we have an opportunity, let's start doing it now. COVID taught us a lot of things. Yes, there were some learning lessons. We need to take those and see how we can overcome it. But the working of private and public was the success factor and shows we can actually work together.
Thank you, Rajesh. I'm going to go to Fatima, and you will then respond to her earlier questions. Fatima, there was a lot of abuse during COVID, around PPE procurement. We did the PCR and the antigen test costs. What has been your experience during COVID?
Thanks. I think it goes to the power, right, of the industry, and I really hope that none of us are all sitting in this room naive to think that we're going to implement NHI and the multinational pharmaceutical industry is just going to offer us the best price possible, and that we're going to be able to negotiate, contracts with the highest levels of transparency and fairness, because that has not been the case in many other diseases, and it certainly wasn't the case in COVID. And just a few weeks ago, we won an important judgment, which basically ordered the disclosure of all the COVID-19 vaccine procurement contracts. Those contracts are now available to us because the minister, took, I think, a very prudent decision not to appeal that judgment, and they are available on our website, the Health Justice Initiative website, in an unredacted form. It's one of the first in the world to actually be made open because we used our access to information laws, and unfortunately we had to sue our own government to be able to get the disclosure of those contracts. But what those contracts tell you, I think, is what we're going to have to grapple with in NHI. And it points to high levels of power, high levels of demands when the state is the single and the only procurer for scarce supplies. And remember that pharmaceutical products, we're not buying cars, we're not buying handbags, we don't have that many choices. Particularly if there's patent protections, you don't have any other generic entries at that point, because you would have these patent monopolies. And recently we saw Johnson & Johnson, the evergreening of those monopolies. So it's very hard for generic competition or other products to come in at a more competitive level. And what those contracts, basically show is that our government, and they've accepted and they've admitted this, was bullied. And they were bullied into not just paying potentially inflated prices compared to global north countries, but also bullied into very onerous terms and conditions on a range of issues. And you can read our analysis on that. So I think for us as the Health Justice Initiative and other groups in civil society, that is the concern. Because if in a pandemic you have an entire ministry and government and the presidency and the Department of Health having to resist such bullying tactics of the multinational industry, how are you going to do this for all health goods, for all time, for all diseases under NHI? Because the formulary is not just about, what's called the NHI formulary is not just about medicines, right? It's also about all health goods. And I think the previous speaker touched upon, the issue of reimbursement and the fact that accredited providers would be able to get a reimbursement. Now, we deal with that and the issues that other jurisdictions are having. In Ghana, in the UK, for example, in our submission on the NHI bill, which we've just submitted to the NCOP. And if you don't address the prompt reimbursement system or that particular model, then you also face the danger of potentially fewer providers being willing to be accredited and being part of the system. And so that's why I keep on having to re-emphasize and going back to this issue of the power. How are you going to regulate prices under NHI when you don't have benchmarking laws in our country, because the industry has resisted that and has fought it legally, when you don't have a new set of patent laws, and Minister Patel really should table that particular bill now, because the NHI is going to operate within that particular global context of the commercialization or the commodification of medical products. So unfortunately, we are really concerned about how the next 5, 10, 15 years are going to play out, leaving aside the potential for legal challenges that almost every stakeholder is indicating that they are going to launch in respect of this particular bill that the National Council of Provinces is now deliberating upon. So I think that people don't want to address the elephant in the room, and that is the power of health providers and the power in relation to setting prices and in relation to setting very unreasonable terms and conditions, which fly in the face of the entire preamble of the NHI bill and all of its good intentions. And I mean, we all support universal health coverage, but there are serious questions that remain that need to be answered. And we really worry that if you leave it to a set of regulations later, you basically lose the momentum and you lose the space in the next few years to try and figure out a robust procurement and a robust negotiation and a robust pricing system for essential health goods. Thank you.
Thank you, Fatima. And Dr. Chris, one of the things that we pick up from the investigations we have in the pharmaceutical sector is the SEP, right? The price at which the SEP is registered. There's no transparency there, and once it's logged into the system, there's really nothing much that you can do. I hope you can also respond to that aspect. Thanks.
Very much. So if I can maybe just respond to COVID and leads into pricing and the earlier questions. I think there are a lot of things that actually were quite a pleasure during COVID. If anything could have been a pleasure, and that is how people rallied around and came to meetings. And maybe Dr. Patel wasn't party to those particular meetings, but there were many, many meetings with all the hospital groups, with pharmacists, with GPs, with whatever, trying to set prices. And as you said, we did come to a point, one day I'll write a book about how it actually happened. But the challenge was, the biggest problem, and why it wasn't really used, was it wasn't one contract. It was 4 contracts in parallel. So you have to contract the hospitals separately, the doctors separately. We thought we needed a lot of physio, so the physio and the other allied providers, and the radiology separately. And then the labs were separate, it was 5, yeah, the labs separately. So we had to get a package of lab tests, and we are working with the Competition Commission at the moment to try and look at laboratory pricing. In fact, I've just come from the Anti-Corruption Forum. That's partly why I was left late. And one of the issues there is around the pricing of the COVID PCR testing. So what was happening was having these multiple contracts. So we would agree with the hospital group, and there's a particular hospital in the Western Cape of a hospital group where they were open. We could admit patients, and the doctor said no. Those are their doctors contracted to work in their hospitals, and they have no control over those contracts to force them. The other thing, which was shocking to me, is that doctors set the standard treatment guidelines. The same doctors who work also in the public sector as well as the private sector, with academia, would design the standard treatment guidelines. In the beginning, of course, it was lots of oxygen and lying on your back. Then it was prone nursing. Then it was something else. But in that process, the private clinicians, physicians in particular, told us, no, we've got different guidelines. If it's all evidence-based, how can there be different guidelines? Well, it means we can treat the patients in the private sector in an ICU because we can charge the medical schemes more. But if we're going to treat the same patient in the public sector, we can't charge more, so we're going to give them a different quality of care. It's not about quality. It was about money driving the market. So there were quite sad things that happened in amongst it. But we did manage to get a fairly high level of engagement and in particular the hospital groups. With the GPs, the pharmacists were vaccinating everywhere. They did nearly 7 million vaccinations amongst the pharmacy groups. It was marvelous. The engagement was unbelievable. But we struggled to get GPs involved. And the main reason was they couldn't get verified to get on the database to be able to get a pharmacy license, section 22A15 or whatever it's called, pharmacy license, to allow them to receive vaccines. Pharmacy groups could receive whole trays of vaccines, and they were moving those vaccines. But a GP on their own, without grouping with other GPs, can't buy a whole tray. They can hardly afford to buy a couple of vials because they're so expensive. So it was the systems worked against GPs participating, which was really sad because there are about 11,000 GPs who could have been involved in vaccinating, and we ended up with a couple of hundred participating. Anyway, so those were some of the lessons in COVID. There were others in working with other government departments, the interaction, and I'll now move on to some of the questions that Fatima was asking. So interacting with the pharmaceutical companies is a one-sided affair during COVID. They had a product, they had one contract that was to be applied to all countries. They would not sell to the private sector. Well, some private sector tried to buy the vaccines. We told them, you're wasting your breath. You have to set up your own no-fault compensation scheme. We knew what were in the conditions. We didn't like it, but we knew what was in the conditions. We knew that you could never buy a vial in the private sector. And you were going to get a price way more than the state was paying. In the end, we did manage to get lower prices than they started off with, but they were still very high. And then the conditions were, you have to buy it all. Even when COVID was like well over Omicron and we were down to nothing, we still had to take delivery of vaccines that were bottled in South Africa, shipped to Europe, and then we had to buy them back from Europe. We couldn't destroy them in Europe because we didn't have a tender to destroy or to store them in Europe. And we had a deadline that we had to get them out of Europe and back to South Africa just to destroy them when they landed here. It was absolutely noose around the neck kind of a stuff. So we are still sitting with the leftovers of that process. And yeah, it's now in the public domain. You can see what we've been dealing with. So when we move forward and answering the question about how we purchase medicines, so at the moment we purchase medicines or we price medicines in two different ways in South Africa. In the public sector, we go out on a tender, which are usually quite big grouped tenders, and we purchase on those tenders. So there are 1,200 products that we purchase in my unit. We've taken it away from Treasury. It's now in the National Department, in the NHI branch, as part of the procurement unit. And we purchase those on open tenders. You can go and have a look at the tender documents. You can see who was awarded what, why they got it, prices that they paid. It's all on the website. Everything is transparent. But we were attacked for awarding a cheaper price. In fact, 1.6 billion rand cheaper for one vaccine, the PCV tender over 3 years. Because one of the manufacturers is a partly state-owned company in South Africa, but selling a product that is actually an American-based company's product, and we bought from a manufacturer who is using an Indian-based product, but they're both South African companies, both employing people in South Africa. So we do have a condition that we will load the price to encourage local market up to 15%, but not 150% or even 100%. We won't do that. It's a health budget. If the Department of Trade and Industry wants to sponsor the development of an industry, a pharmaceutical or other medical product industry, that's their business. We work with them on that, but they must find the money out of their budgets. We're not paying it out of the health budget. So that's how it works in the public sector. And we get good prices. We have the best antiretroviral prices in the world by quite a long way. Because of this monopsony of having huge volumes and good data around those volumes, we do get good prices. We never, unless there is only one supplier, like which is the morphine problem at the moment. Well, it's actually not at the moment. Right now we've got a liquid morphine, but we have had a problem a few times because there's really only one supplier. Otherwise, we always split the tenders to make sure that if there's a problem with an API or one or other importation problem, we are always able to get the products. In the private sector, it's the SEP process, single exit price. And the formula and the way in which the single exit price is managed is a problem. It's now become my problem because it's now in my branch, and I've been sitting with the minister and with the pricing committee. We're about to have a change of pricing committee now. We're about to have the new SEP for the new year will go out. We've had a big bun fight over the last SEP. I'm sure you're aware it was just over 3.5% or 3.28%, and then we had to do an adjustment in the year because we were losing pharmaceutical capacity in the country. So there's that balance that needs to be reached. But how the first SEPs are even arrived at and how the annual or in-year SEP adjustments are arrived at is something that we definitely can improve on, and we know about that. Fatima talked about benchmarking. We do need to benchmark. We need to put that in the new regulations about benchmarking, and we need to make sure that when we benchmark, we don't benchmark on UK, United States, Australia, and that we also don't benchmark for all medicines on the same countries. If we have a particular profile of mental health, for instance, we need to find countries in the same sort of socioeconomic group as us, and we need to benchmark on mental health interventions, products in those countries. So we know we need to segment it, we know we need to do that. What we believe we will do, based on the sections that Fatima is referring to, I think it's section 35, is to use this expertise we have currently for purchasing public sector. And as more and more providers are accredited, they will be able to purchase at the price that is achieved by the fund through this same pretty much the competition process that we use at the moment through tendering. So that's benchmarking, tendering, and then the third method that we do sometimes use is there are some alternative pricing methods when it's like 5 or 6 patients with extremely expensive medicines, and we have to go and individually negotiate prices to be able to serve those patients. Last comment is that for the transition period, we are going to need to run parallel systems for pricing, and afterwards, we are still going to have, for those benefits that are not covered by the fund, there are still going to be products that are available that may not have passed the formulary test, they don't pass the HTA requirements, and I'm now not only talking about medicines, other products as well, and there's going to need to be a competitive space for having those accessible for patients who are covered under Section 33 by medical schemes. That will be a process, and I have my concerns, the same concerns that Fatima has, and we need to tighten that as much as we possibly can as we move forward.
Thank you, Dr. Crisp. I think at this point, I would like to open the floor for the audience if there are any questions. All right, I don't see any hands. Oh, there's one hand inside.
Okay. Thank you. I have 2 questions. I think I would like to latch on your question around implementation of the HMI recommendations. So there's one which you asked about tariffs, what has been done so far. I think I did not get a response on that particular one. So if we could get feedback on that one, that would be nice. And then secondly, I would like to note that the structuring of medical schemes and benefit options is incredibly complex. What we currently are sitting with, it's a result of other factors. It's not that schemes voluntarily choose to have many options. Has an analysis been done to understand why we have so many options? Because it would be easier to address the root cause rather than saying, let's do away with options. Still on options, the response to trying to implement the recommendations was trying to align the current benefits with NHI benefits. How does that correlate with Section 33, which states that schemes will only be offering complementary cover? I'm failing to get the rationale of the path being followed, as well as Section 33 of the NHI bill? Thank you.
It's James Hodge from the Commission. I mean, market power is certainly one factor, and we've seen that, but cartel activity is the other, and we also saw that in the public sector with PPE. I don't know what the private sector experience was, but I would just be interested to understand what the Department of Health experience in their current contracting is around that, and also whether on the private sector side there is some experience in the toolkits to detect and deal with cartel procurement.
Thank you, James. I just got one question on WhatsApp. The question is, what would be the role of medical schemes as we transition towards the NHI? I would address that question to both you, Rajesh and Dr. Kaban. Maybe Dr. Chris, maybe, if you could respond to the tariff determination question. Tariff determination. Tariff determination. Tariffs.
Okay, so I'm sorry, we're having difficulty hearing here because all the sound is coming to you, and two of us are obviously clearly very deaf. So in terms of, when you talk about tariff determination, we're talking about the product, what the providers are going to provide in the NHI. Is that what we're talking about?
No. So one of the key findings of the HMI was the lack of tariff determination mechanism. Okay. And how are we resolving that as we are transitioning towards NHI?
Okay, so I think we're meeting with you next week. As far as I know, we've had a couple of video conferences or whatever, just trying to get an agenda together. But as far as I know, it's either next week or the week after. And we've been talking to CMS a little bit about our thinking of how we would be able to do that. So we're in broad agreement, let's put it that way. How we actually do it and who manages it is really the issue. And a constraint for us at the moment in the Department of Health is that we don't have staff. All our posts have been frozen. We will not be allowed to fill any posts. And we've just had to, in this financial year, give up over R1 billion of our current budget. And we are being cut again next year. So while the private sector put theirs up 9%, we get ours cut by somewhere around 9%, and we have to absorb the salary increases, which amounts to a 7.5% cut in our salary. So we don't have staff to implement the things we want to. So we're trying to be a bit creative in our early discussions with CMS, but the three of us, the Competition Commission, ourselves, and CMS will meet in the next week or two, and we'll exchange ideas thoroughly at that point. But I think in principle, what we are looking at, we are not in a different space. And what is in the health market inquiry about having the forum where we consider tariffs in this transition period is very much something that we have in mind anyway. Ultimately, it will be the advisory committee on pricing that will be responsible for that. But I think we're a couple of years away from that still.
Can I respond to that? I think, if they've got a shortage of staff and therefore can't really implement something, and if you're still going to talk about it and potentially implement something, there's year-end coming now. We've been going for almost 2 decades where there's been a vacuum in terms of tariffs, etc., and we need to provide people with certainty. And in fact, just recently we had a complaint about a cardiologist charging 8 times the scheme rate. And that's just one example. There's multiple or similar examples. There was a case that we dealt with about a decade ago where a cardiothoracic surgeon charged about 150,000 Rand for an estimated 5.5 hours work, if you could put it that way. And you can do the calculations of what that practitioner thinks is worth. So the critical component is then, if there is resource constraint between the regulators, government, etc., what is the problem in terms of the private sector engaging providers and funders, and we negotiate with them, come up with certain tariffs or negotiated prices amongst ourselves that's reasonable, acceptable, and potentially generally accepted. What is the hurdle in us going ahead and doing that? Where is this? I know you're aware we applied for exemption, and that's been going on for almost 2 years now. December will be 2 years. What is the holdup? Why can't we just go ahead, negotiate, provide the public, and including many of the people in this audience, with certainty out there? The doctors are willing to sit around the table with funders right now in a collective way to be able to determine rates. We've done some research on administrative determination of annual inflators, etc. Why can't we sit around the table and start going ahead with that? Why do we have to wait for the regulators to make sure that they get their house in order before we can have certainty in the environment? So I'll be honest with you, I'm not happy with what I've heard. I think it's great that you're going to be working on a solution, but I'm not happy that the industry and the public are held back from certainty in terms of what they can do to control tariffs and prices. Absolutely critical at this point in time. I think on the medicine prices, just a quick comment on that. The biggest problem in medicine price and the SCP is that the pharma companies lodge their price, but there's no interrogation of that price, whether it's appropriate or not. And we've seen equivalent, and I'm glad you're investigating just the TB. There's a whole lot of other ones like the biologics that potentially need to be investigated. Department of Health produced the health economic guidelines, but it seems like no one uses that to justify their prices or even interrogate that component of saying, where's your price? I'm not sure pricing committee looks at that at all as well on the medicine side. I know you asked us, Dr. Kaban and myself, so I'll pass that over to him, and Dr. you weren't going to talk about it.
A question was asked in terms of what blocks, the private sector from being allowed to determine tariffs, without the involvement of the regulators and government. I think part of the problem sits with the basic principle that you can't be a player and a referee at the same time. You need somebody that's going to facilitate those processes, make sure that the powerful players don't bully those that don't have power. So what's lacking right now is that if you just gave that power to the players themselves, some of them don't have the legitimacy that sits with government, that sits with the regulators, so that when people feel that they've been treated unfairly through those processes, there is a process of redress. So I believe that regulators and the government have got the legitimate power to coordinate and play a stewardship role over those tariff negotiations. And let me just remind Dr. Patel that during COVID, there was a concerted effort by the regulator to bring the industry associations to determine how, to come up with a plan of how tariffs could be determined. And we sat together and we collaborated. And there is a framework that is in place, which we shared with the Competition Commission, as well as other players. So when Dr. Crisp says we're in agreement, we're going to bring together all the various inputs, that framework is also going to be considered. So he's not by any means suggesting that this process will start from scratch. So all the inputs are there. It's just a question of key people sitting and looking at whatever inputs have been made and having an agreement on what is going to work best. But I think, the fact that progress has been slow mustn't push us into being reckless and irresponsible, because there are consequences, to these kinds of things. So we're just saying, yes, there are challenges, but give this process a chance. I know often when people, criticize these processes, it's because they're in a hurry to look for benefits, And I think it's important that we make it a transparent, responsible process, and that no one gets, disadvantaged through that process.
I would love to respond to that. I think the comment made is that you need an independent person, oversight, etc. I think one of the things we said even in our submission is that for the exemption is that when you get your house in order and you're ready, we're happy to hand over to you. In the meantime, allow us to engage with willing parties out there to be able to negotiate. As far as the independent voice and that is concerned, and to protect people from powers that are in the environment, one of the things we said is that to make that as transparent as possible, you get the consumer representatives, people like the trade unions, employer groups as well in that process, because contributions are made by employers in subsidizing members. Most employees, most people on medical schemes are people who are employees of some sort or the other. And therefore, if you have union representatives, you have consumer representatives in those negotiations, that will keep the funders as well as providers honest in those negotiations. So we've never said no to having independent people part of that oversight process. What we want is certainty sooner. We obviously can, yes, you know, if you come with that suggestion next month, we'll be happy to hand over to you. But the point is, why hold the industry back? And I think that's the critical component. If the role of government, institution like CMS, Competition Commission, is to protect the public, and if the processes are slow, why hold others back from being willing to protect the public, especially when there's no price certainty for healthcare services? Healthcare services in South Africa is not a commodity. It is a public good. And therefore, there's an obligation on all of us, whether you're government or non-government, to make sure you provide price certainty and make sure that the quality component comes along with.
For me, I think it's just a comment and question. Yeah, on the comment side, I think Nicholas referred to the issue. It's more a pharmaceutical issue. I think when the BioVac and CIPLA issue about the tender that was awarded to CIPLA by the department, my first reaction was, but how could this be? And obviously then I read the Department of Health's response. And now Dr. Chris makes his point that basically our KPI is to get the best possible price, which they did get. But I still think that there needs to be a broader countrywide view. It may be, I'm thinking about this product now, but it could be other, that, you know, if you, within reason, you purchase within, I mean, using a high, based on a higher price, but is the net impact on the economy served by that product that's cheaper by 1 rand a unit? So that's a statement that basically says, I would hope that we look at policy congruence across all departments with a view of looking what's best for the country, because BioVac has been nurtured by government for almost 2 decades. And during COVID, it seemed like it was really now getting to produce products, and then the first publicized tender they didn't get. So I know it's deeper, as Chris said, but all I'm just saying, and the nice thing is it's not relevant for this house because you're still under Department of Trade, Industry and Competition. So ultimately, I think our policy needs to speak to that. It's related to the second one, which is actually a question still on the same subject. We know that even though manufacturing in generics in this country is quite decent, but not on what really matters, the active pharmaceutical ingredients. We used to argue so much about this that we'll always be last in line on ARVs, that we need ARVs so much in this country. And what happens if where we source this from, we are not priority? And then it just happened as part of the COVID vaccine while we were looking at the ARV side. But I hope again that the Department of Trade and Industry looks at that, because at some point most of our local manufacturers of the finished ARV product are competing with their suppliers on the active pharmaceutical ingredient from elsewhere. So how can they ever beat those prices? Now, the question is, you can take a narrow competition view and say it's the best price, you don't care. Or someone could say, well, you know what, the issue of getting the local manufacturing industry going, what can government do to facilitate acquisition of APIs and local manufacturing? And you don't need all APIs. Just identify 5 or 6 molecules that are critical for us. So I think that will go a long way in dealing with the price, which ultimately is about affordability. And then my last comment is just, when I first looked at the question as to what has happened since the HMI, I would have said nothing. But we've heard quite a bit from Dr. Crisp and Dr. Kaban. I just wish they communicated more what they're doing, because it seems from the outside nothing's happening. But we heard today that there is a movement in the background. Thank you.
Thank you, panel members. We've run out of time, but I've requested 5 minutes for you just to each make some conclusions. I'll start with you, Dr. Crisp.
Okay, thanks very much. Look, I think for me, the health system is very messy. It's overcomplicated, over-duplicative, and if you've just seen the presentation I've just seen from the Health Anti-Corruption Forum, you'll have a heart attack if you see what's going on in both the public and the private sectors. It seems like it's even worse in the private sector than in the public sector. We need to share all of that information in broader forums, and we need to tidy up the ship. There's lots of money that is being wasted. We need to organize it better. We do need to have these kinds of discussions and make sure that there's fair and there's competition, but not at the cost for the patient. At the end of the day, it's what Rajesh was saying. It's the patient that we are trying to focus on. Health is a public good. And if we are just trying to find out ways that we can cream it, we are not doing anybody any favors. We still think the framework of the NHI is the appropriate one. We accept that there's a lot of detail that will come in the regulations as the clauses are brought into effect. We will definitely make sure that there is transparency and consultation in those processes. But if we don't change the way we do things now, we are just heading for an even bigger hole. Thanks.
Mic is off.
Fatima, are you still there?
Yes, I am.
Yes, your concluding remarks.
So I think, there's an admission that we're going to have a parallel pricing system and a parallel product procurement system for the foreseeable future for some time, because it really will depend on when the minister issues its determination that medical scheme can no longer provide what the NHI will provide. So that may take, I don't know, a decade, 2 decades, we don't know. So I think what that suggests is that the work that we need to do around proper regulation, and unfortunately at the moment that seems to be only the Competition Commission who, has the regulatory and other investigative type of powers to do that, because I think Nicholas is right. There is a lot of profit being extracted out of the health system, and it's actually not, government's money. It's our money. It's the public's money, whether it's in the public or the private sector. We users in both systems, and I think that the transparency, I think, is really critical going forward. So there's 3 things I want to say: that the regulation is going to have to be ramped up by the different regulatory bodies, particularly the Competition Commission, in both the public and private sector, even under NHI going forward. That unfortunately means that civil society are going to have to do case-by-case drug gouging sort of inquiries and complaints and referrals, including patent oppositions. And I think that some consideration has to be given by the Minister and the Commission to reintroduce some of the speedier, expedited investigation processes that they had on price gouging for PPE, for example, or PCR tests under the pandemic. Because I think expecting the public to wait 12 to 18 months for an investigation to be completed when there is a lot of evidence and there is a lot of information, I think doesn't make sense in this particular context of a recession, of an economic crisis, and the high levels of inequality that we're facing in our country. Thank you.
Thank you. Dr. Bengo?
Actually, my last comments covered that. All that's left is for me to really appreciate beyond the HMI what the Competition Commission has done behind the scenes in really pushing for the implementation of the market inquiry. Obviously, the Department of Health, that's your peer. I understand very well how much, especially the specialist groups, have been, simply because I was in the part of the inquiry, they tended to come to me basically say, what can we do? We accept we were found wrong in some places, but we want the pricing thing to move. And they always came back to say they do find a receptive yes in the Competition Commission. So when we hear that there's a meeting scheduled next week, that's exactly what I think the industry needs. Thanks.
Thank you. Rajesh?
Yeah, two comments. I think the one component we just touched on, but we missed out on, is the whole issue of trade practice that's going on out there. To give you an example, the rebate issue that BHF exposed in 2007. Yes, it's got transferred across kind of thing, and the tariff stuff, till today that practice is ongoing. How are we going to deal with that? You go to any mall out there, you see on these optician walls, the windows kind of thing, 1+1. That immediately tells you there's perverse pricing in those services. How are we going to deal with those components? And this is why the urgency to get to the negotiating table as quickly as possible. The last component is about NHI and medical schemes. Why are we developing a monopoly in NHI? Is government afraid to compete with medical schemes on the same basket of services? And why do we need a monopoly and medical schemes marginalized? Let's allow competition to take place between NHI and the medical schemes for that same basket benefits out there.
Thank you. Dr. Kabanya?
I just think that the challenges that we're faced with are complex, and that none of us as a singular group can achieve them, and that we need to work together. So, concepts that says, allow us to run, it means you'll be quick and you'll get to your destination quicker. But if we go together, we'll go further. So I'm just saying, let's start working together. Let's leave all this, point scoring, talk to one another, even during those difficult times. And I think if there's anything that we learned from COVID, was that it brought people that were diverse in thinking, that were diverse in terms of ideology. And yes, we did score victories. And I don't want us to underplay those. The fact that we were able to collectively get the prices of PCR, dropped, it wasn't because it's the CMS that complained, but it was because of the support all around that existed then. And I think we can build, on some of those positive results that we've achieved, instead of, destroying the current relationships. So I think more collaboration, more success. Thank you.
Thank you very much. It's been a wonderful discussion, panel members. Can you please give them a round of applause? Thank you.
Thank you, Mapato and panel. Because Karabo and I are feeling very generous today, because we've had such a great audience, we're going to ask that everyone get a 10-minute comfort break, and we should be back by, she says 20 past. Yeah, it's not me. Yeah, you know when 10 minutes is. Thank you very much.
Welcome back, ladies and gentlemen. 10 minutes was 15:23. It is 15:33 right now. So I said to Efente, there's a reason why I don't like being generous, because people take advantage. So what we've decided we're going to do is that cocktail is going to be for 10 minutes only, so that we can all see what 10 minutes looks like. Okay, we are going into our last session. Hey, yeah. Offense. This one looks like a tough one. I don't know.
It's a tough one because I can tell you now that when Upax was told about this topic, he realized that he would be in trouble, so he went and asked Mr. Manager to come and help him. And then when everybody else realized that they've brought the big guns, then the powers that be fetched Jerome to come and balance things out. So the topic for this next plenary session is development of appropriate legal standards. I think for those of you, and I've looked around, I see that we don't have too many young people around here. You would remember a song by a woman called Vanessa Williams that says, "Save the best for last." If I could sing, I would, but I don't want to torture any of you. So I think let's just keep the memory of that song in our minds and just get on with it. Thank you very much.
Hello. Testing. There we are. Hello, everyone. My name is Mpumelelo Mpumi Chabalala, and I work at the Competition Commission of South Africa. I am joined on this auspicious panel by Andrei Tsiganov, who is the deputy head of the Federal Anti-Monopoly Service of the Russian Federation. I have on the other end Bukosibake Machenge, the Chief Legal Counsel and Divisional Manager of the Legal Services Division at the Competition Commission of South Africa. I also have, just next to him, Jerome Wilson, who's a Senior Counsel of the Advocates Group 621. And then lastly, I have Mwako Maineje, Senior Counsel of the Duma Nokwe Group of Advocates. Now, it's a Friday afternoon. It's after 3, and what I want from this session is just for us to have a great chat. At the end, I will have time for questions from the audience, so I hope that you all listen closely. But getting on to a development of appropriate legal standards. Now, thinking about the pre-amendment world, people would say that enforcement, up until now, has been a period of under-enforcement. If you look at the statistics, we've got about 29 abuse of dominance cases that were initiated and referred, only 8 confirmed. 5 to 8 years is what it takes to take one of those cases to completion. Mondo this morning took us through some of the journey of the interim relief applications, how they waxed and waned over time as legal standards have changed. There certainly was a dry spell in which interim relief applications weren't being brought at high number, and they also weren't being granted at a high number. This is in a context where we're in a developing country. What that means for us is that we're litigating against global firms that have strategic decisions and information all being held in head offices that are extraterritorial to our jurisdiction. Those kind of jurisdictional debates are what come in the form of interlocutories, and we have seen their number. What has been described by case law as a Stalingrad method of litigation, we've had respondents bring up interlocutories of all kinds that suspend the amount of time it takes to get to the merits of a matter. Furthermore, we are in a highly concentrated market, one in which we cannot rely on the market to correct itself, as some may say is happening in other more developed countries like the US. And even we heard yesterday that in the US, government intervention is seen as imperative now. High litigation resources, many number of interlocutories have calcified into a case jurisprudence that some have said has perverted the rule of reason analysis. The evidential burdens on prosecutors are high. And when those prosecutors are private prosecutors, perhaps small to medium enterprises, historically disadvantaged firms, the burden is even higher. This is in a context of high inequality, high levels of concentration, high unemployment, high poverty, and also where the small to medium enterprises employs about 50 to 60% of our workforce. We heard from Rachi yesterday about the fact that small to medium enterprises are not only struggling to expand, they're struggling to survive. This is the context in which the amendments were founded. The amendments, I believe, are radical, and I say that with a smile. On the one hand, you have an onus shift in the form of a prima facie case that has been established through excessive pricing, buyer power, price discrimination. You've got certainty around the various factors that need to be taken into account around excessive pricing, around predatory pricing, and things like that. Furthermore, the effects test could be said to have been watered down with the amendment to the price discrimination section, which says likely to have an effect, not proven effect, likely to have an effect. We also have the holy grail of competition law's liability standard, the significant prevention and lessening of competition having been changed for various different sections. For market inquiries, we're now looking at an adverse effect on competition, the meaning of which relates to the impeding, restricting, or distortion of competition. We look at unfair prices now in buyer power. And then we've got that tricksy word, participate. Who knew that it would come with so much jurisprudence? But participate effectively is now the standard introduced into price discrimination as vis-a-vis small to medium enterprises and historically disadvantaged firms. Participation, or exclusionary conduct, which used to relate to a firm's ability to enter into and expand within markets, has had participation added to it, its ability to sustain itself in a market, which, as we've seen post-amendment with, for example, the e-media case, the Normandin test where that case failed because the plaintiff was unable to establish that though there were effects on them as a single player, they weren't able to show that those effects were market-wide. In the e-media case, we see that exclusion and inability to participate by an HDP firm was enough to get them through across the bar. We've seen with the serendipitous advent of COVID-19 colliding with the fact that the prima facie case was introduced into the excessive pricing section, Babelegi, Dis-Chem, Tsutsumani, Blue Collar, all be successful. We've also seen Mediclinic. And what Mediclinic has introduced is a suffusion of the Bill of Rights into our understanding of substantiality when we look at the SPLC test. So there's much more to be said about how the post-amendment legal standards are going to take us going forward. But that's what I want to hear from our panelists today. And to start, I'm going to swing to Andre, who's going to give us a comparator on what it's like on the Russian side of things.
Thank you, Chair. From my point of view, it's a very good idea of organizers of our conference to finalize it with this session. Because 2 days, we are talking about standards, we are talking about legal certainty, and maybe during this session we'll find some conclusions on this discussion. What are the sources of legal standards from my point of view? First of all, of course, it's provisions of law itself. very important is the role of decisions of courts, especially the highest court instances. Soft law instruments are, yes, nowadays it's it's inseparable part of competition regime, and it establishes, if not the standards, but the limits and the boundaries of legal and illegal behavior of market participants. And of course, international legal and paralegal documents are very important because, as you, Chair, told just now, it's a global market. We work not only on our local markets, we work with the transnational corporations, trans-border cartels, and other very serious and harmful violations of competition law. The essence of legal standards is to determine, or maybe direct, the behavior of market participants and of competition authorities and courts at the same time. And as well as interaction between all these parties involved in the process of decision-making and of implementation of competition law, of enforcement. When the system of legal standards is appropriate, from my point of view, it's it's a balance between conservative nature of any legislation, of conservative approach of courts, and stability of legal system from one side, and the constant development of legislation and law enforcement based on evolution of economic life in the country and social life as well, on the best enforcement practices, on international experience, because the family of competition authority is worldwide, more than 100 friends and colleagues. The Russian competition law that was adopted and enforced 32 years ago, from my point of view, is a good example of evolutionary development of legislation based on external factors like the development of new economy, new industrial revolution, digital markets, globalization, and so on and so forth, and huge experience in enforcement practice in our authority. You talked about the under-enforcement, but some of our opponents claim us that we are over-enforcers, because it's more than 1,000 cases of abuse of dominance, 400 cartels, a huge number of unfair competition cases, and every case is a new drop to our experience in competition law enforcement, and a lot of our cases are appealed to the courts. So the courts have this intensive experience in making decision on competition law enforcement cases in our countries. But at the same time, the basic system of prohibition, the procedural rules are stable. So it's really an evolutionary way of development of Russian competition law. And from my point of view, it's very important to find this kind of balance. Yeah, just now.
I'm audible? I'm audible now. Thank you very much, Andre. We're going to swing over to Jerome. We would love to hear your thoughts on the development of appropriate legal standards, past, present, future.
Mpumi, my 2-second lag has caught up with me. Mpumi either asked me or thought I would in any event be the antagonist in the afternoon discussion. So let me not disappoint her, and let me be doubly unpopular because it's happening on a Friday afternoon before your cocktails. I thought, though, it might be helpful for purposes of stimulating the debate, just to pick at some of the strands of this ongoing, and I must say, very fetid discussion of constitutional values as against competition law values working itself out under the Competition Act, highlighted most recently by the Mediclinic judgment that many of the lawyers may be aware of, and the consequences of that in various subsequent decisions that have come out. And I suppose the starting point is to consider to what extent it can be said that the norms and objectives of constitutional law are entirely coherent with those of competition law. Now, at some level, of course, it must be the case. We exist in a constitutional state. The Competition Act is subject to the Constitution. That's not the discussion. I think the discussion is more when you come to certain of the values within the Bill of Rights, when you come to thoughts of dignity, of equality, matters of that sort. To what extent are those always consistent with the objectives of competition law, which at least historically has been concerned with efficiency, with consumer welfare, with providing incentives to innovate and invest, even if you're a large firm in the market. And the debate is whether the process of competition, because ultimately competition law has always, at least historically, been regarded as a process-oriented notion, necessarily gives rise to outcomes, which are the constitutional values that we see in the Bill of Rights and that are accentuated by the Constitutional Court in cases like Mediclinic. What happens in a situation where the process of competition, at least as reflected and enforced by the Competition Act, doesn't necessarily get you to the constitutional values you want: transformative economy, dignity, equality, equity? How does one solve that problem? Does one solve that problem within the structure of the Competition Act by amending the Act, by interpreting the Act in more and more radical or perhaps non-standard ways? Or do you look at some other mechanism of solving what I think is this problem? Now, for the most part, one would say constitutional outcomes and competition outcomes pull in the same direction. Of course, participation of the previously excluded in the South African economy is fundamentally important for the process of competition. It's fundamentally important for the growth of the economy. Conversely, you would say a growing economy is very important for new entrants into the market. The bigger the pie is, the better it is for new entrants into the market. You don't simply want to, in the old adage, have a bigger piece of a declining sized pie. How does one regulate that particular debate? So on the one hand, you would say there is largely confluence between constitutional desires and outcomes and those that are sought to be achieved by the process of competition. But I think if we're intellectually honest, we must accept that there are going to be some situations where at least traditional notions of competition law are not entirely overlapping with the objectives of the Bill of Rights. And in mergers, we have seen developments where you would have a merger which may be good for efficiency but results in a loss of employment. Now, in South Africa, we have grafted onto our Act a public interest element in order to address that problem. What hasn't yet been fully addressed, though, is in the prohibited practice side of the Competition Act. There we have, as Mpumi indicated, still a very traditional standard of a lessening of competition. And yet, on the other hand, we have a slew of cases now coming through the competition authorities where HDPs want to participate. They want there to be a duty on behalf of dominant firms to deal with them, even if it does not it's not required from a strictly competition law perspective. In other words, inclusiveness is demanded, notwithstanding that there may not be a traditional test of an anti-competitive effect met by the refusal to deal. And to what extent is that going to be accommodated in our Act going forward? Now, as Mpumi said, amendments are the one easy way to do that. At least from a lawyer's perspective. From a political perspective, I'm sure that's the hardest way to do it. But from a lawyer's perspective, it is very easy for us to see in mergers there is a public interest element, and we can now engage with that. In certain parts of the prohibited practice provisions under the new amendments, there has been built in a non-standard competition law test, whether under the price discrimination provisions where you have an anti-competitive effect or a deleterious effect on HDPs. Likewise, under the buyer power provisions, you have notions of fairness which are coming into the debate, which again are not totally in sync with traditional concepts of competition and anti-competitive effects. But there is still an excluded element which is now battering on the door of the competition authorities, which is in those, can I call it classic and traditional sections of the prohibited practice provisions of the Act, where there hasn't been an amendment in order to promote diversity in the sense of a reduction of an anti-competitive effect standard. What is to be done? Until such time as Parliament makes further amendments to those acts, we as lawyers are stuck with the Act as it is. And then it becomes a question of constitutional interpretation. How far can a constitutional interpretation of an anti-competitive effect standard get you in the absence of a specific provision for a public interest effect or for an effect on HDPs? And I think that is the new frontier, to my mind, of competition law in South Africa. I think lawyers are wrestling with this notion of how we are going to develop the prohibited practice sections, and in particular abuse of dominance, in order to deal with what I think everyone accepts is an insufficiently transformed economy without necessarily harming all of the traditional notions of competition law that are sought to be achieved in incentives to invest, efficiency, and the like. So I think those are the tensions that we currently have. I think there is an exciting new debate, which hopefully we can have partly today, and it will certainly be had through the court system, through the Commission, through the Tribunal, and the higher courts. There are, I think, more questions than answers at this stage, and I would be interested to hear views and questions from the audience on that in due course. Thanks, Mpumi.
Thank you, Jerome. We will have a second round where I can probe you on what you've just said. But I'm going to hand over to Hamilton now. I'd love to hear your thoughts on the development of appropriate legal standards.
Thanks, Mpumi, and thanks to the audience. I think Jerome poses a fundamental question because it goes to the start of trying to understand where the Competition Act must go to achieve the purposes that it advances in Section 2, read in light of the Constitution. And the crux of his question is, what is the answer when they pull in different directions? And I think he's quite right that when they cohere, is unlikely to be a problem. But I would suggest that the Constitution and the Competition Act provide the answer. Might not be a clear answer in that the actual answer will depend on the problem that you face. And I picked up a case which I will refer to later about how in the application there is potential to undermine the purposes of the Act and a constitutional approach. So I think we should start at the beginning, that at the crux of apartheid was economic exclusion. And the Constitution and the Competition Act are aimed at reversing that exclusion. The exclusion resulted in no participation by previously disadvantaged persons. It resulted in highly concentrated markets in the hands of few people. And so when one wants to understand what our Competition Act is intended to deliver, one starts there and goes to the preamble to the Competition Act. And you will see from the preamble that it references the impact of apartheid, that our economy is not open, we have high concentration and lack of participation. And in the purposes, it repeats those things, but it also promises that consumers must have certain goods from the Competition Act. So you must have an economy that is, an act that promotes efficiency, adaptability, and development of the economy, which are the economic goods that Jerome references. But it also guarantees that consumers must have competitive prices and product choices. Those have implications for the Bill of Rights. Must promote employment, have direct implications for the Bill of Rights, because there's a protection in Section 23 of the Constitution against fair labor practices, which include retrenchments and so on, which are consequences often of mergers. You must expand opportunities for South African participation in world markets. That again goes to the competition efficiency point that Jerome references. E, to ensure that small and medium-sized enterprises have an equitable opportunity to participate in the economy. That one must read together with the last object regarding participation by PDIs, because often those will be in the form of small and medium enterprises that are dependent on the big dominant firms for supplies of goods and services that they require to participate in the markets. And so, and that directly implicates both the efficiency point, the traditional economic efficiency point, because we accept, and the minister spoke yesterday about industrial policy, that it's critical that we develop small and medium enterprises in order to increase competitiveness in our markets, to counter the dominance and concentration that you have in markets. So that addresses both the efficiency point, but the transformative agenda. And you must, as I say, link that with ownership of PDIs. Now, what does the Constitution tell you when legislation impacts rights? It says in Section 39(2), instructs that all courts, all adjudicators must interpret the legislation and apply it in order to promote, protect, and advance the Bill of Rights. So that is the answer when there is tension. Your first port of call is to ask whether there is an interpretation of the legislation that better advances the protection of rights. And the Competition Act itself invites adjudicators to do just that, because it says in the interpretation section that this act must be interpreted in a manner that is consistent with the Constitution and gives effect to the purposes set out in Section 2. So what often happens with this recourse to traditional or historical competition or purposes of competition law is a call to go back to America, to go to Europe and ask what the purpose of competition law is, as if there is an immutable purpose that competition law must serve. But it isn't that. And that frees us from that if we appreciate that that is not the position. That we have the freedom to choose what our competition policy is and what we want to achieve with that policy. And that policy is consistent with the Constitution. That's why there's no constitutional challenge to the Competition Act, because it gives effect to the Constitution. Now, and when I discussed the Sekunjalo judgment, which is controversial, I accept, and people have different views, you will see that in the application of the provisions of the Act which have been amended, the application of theories of harm can actually hinder the achievement of what you seek to achieve by the amendments that you see in some of the provisions of the Act. And often adjudicators and practitioners that appear before these authorities appeal to theories of harm as if they are themselves legal standards, when in fact the legal standard is derived from the interpretation of the statutory provision. The theory of harm is simply an explanatory tool that generally it's accepted in economics that certain conduct is likely to give effect to anti-competitive effects and justify a prohibition. But it doesn't mean that theories of harm are set in stone. They must yield to what we say are the purposes of the Competition Act, which we have enshrined in Section 2 of the Competition Act. So I suggest that the answer first lies in a proper interpretation of statutory provisions in the Competition Act, to understand in their language, purpose and context, what their meaning is. If they are capable of a number of meanings, you always prefer the meaning that better promotes rights under the Bill of Rights. And that's how Mediclinic was determined, is that you have one interpretation which goes to the old school of what competition law is about, which says Section 12A, if you have a price increase post-merger, you must ask whether that price increase is the result of an enhancement of market power. That may be the case in the US, that anti-competitive effects must arise from an enhancement of market power, but you don't have that under our Act. Our Act simply asks whether the merger gives effect to anti-competitive effects. Might be a price rise which has effects or likely effects on competition. So always the framework is, what is the meaning of the statute? If it's capable for more than one meaning, you don't go to historical competition, purposes of competition law. You ask whether there is an impact on rights and whether there is an interpretation that better promotes rights. And that's the interpretation you take. Thank you.
Go ahead. Thank you, Nwako. You know, Jerome on the one hand is saying, is this the vessel? And what I hear Nwako saying is, the vessel is empty. We make the vessel. We decide what goes in the vessel, the competition vessel. But over to you back here. I would love to hear your thoughts on appropriate legal standards, past, present, and future.
Yeah, thank you, Mpumi. I've listened very carefully to Advocate Mainek, and I was specifically on the lookout for errors in what he said, and I found none. I think the first question, as Advocate Mainek points out, is one of location of the Constitution. So obviously, competition law and the Constitution are part of the same legal system. And there's a risk here in the debate of selective application of the Constitution. In this sense, when it comes to the exercise of investigative powers by the Commission, we insist on constitutional control of those powers under the principle of legality or under the Promotion of Access to Administrative Justice Act, if the Commission's decision amounts to an administrative action. So on the exercise of coercive powers, we are very clear about, and there's no debate or contestation about the application of the Constitution. But when it comes to the substantive aspects, that is the meat of competition law, then there's uneasiness about the application of the Constitution. So there's sort of a schizophrenic approach to the application of constitutional law to the competition law sphere. So there is that risk, I think, of schizophrenia. But we know that post-Mediclinic, competition law is firmly embedded within the constitutional framework. The second point to make is that even if we look at the evolution of competition law in the US as well as in Europe, it has always been a response to the economic imperatives of those countries. Look at the evolution of antitrust law in the US. First, we see a concern about market power. And then as these firms grow, that is US firms, under the Reagan administration, we then see a concern about efficiencies. I'm not suggesting for a moment that in the earlier epoch of the evolution, there wasn't concern about efficiencies. But I'm simply pointing to the fact that the development of competition law, even in the US, it's always marked by the economic context. Same as when we look at Europe. EU competition law is concerned with questions of economic integration and the functioning of the European Union. So that is the main preoccupation of EU competition law. So it's very natural for South African competition law to be concerned with questions of transformation as well as economic concentration. So it's in keeping broadly with the evolution of competition law globally. So it's very difficult to conceptualize competition law as this island that is in a sort of a bubble, insulated from the economic realities of a country. So it is within that context that we then have to approach this question of economic standards. Because the Act, the Competition Act of South Africa, it's an expression or a reflection of the legislative policy choices made by Parliament to respond to the economic context. But what we have seen, if one retraces the trajectory of the evolution of South African competition law, those legislative policy choices do not match the jurisprudential outcomes through, of course, a process of the mediation process that arises from juridical engagement with the provisions of the Act. So that process of juridical engagement or judicial engagement with the provisions of the Act has not always matched or has not always been faithful to the legislative policy choices made by the legislature. And we see this, I think, in a number of cases, but I think this is more pronounced in the area of cartel law, where we see a complete diffusion of the legislative policy choice. One could even say a complete erosion of those legislative policy choices. The same thing, of course, has played itself to some extent in abuse cases, but not with the same level of severity that we see in the area of cartels. But even in abuse, we do observe the same phenomena. Thank you.
Okay, so we've got a response this side. I think let me hand over to you, Jerome, in response.
Thank you. Continuing with my role of devil's advocate, I suppose everyone says the advocate is always the devil, but let me let me just in response to Nwako's thoughts remind us that the preamble is not the act. The preamble is the preamble to the act. You look for the purposes of the act to section 2, and what's very important, because at the end of the day, this is still a competition act. It's not another kind of act, it's a competition act. It refers to the purpose of the act being to promote and maintain competition in the Republic in order to achieve all the objectives of the preamble. So of course the preamble is incredibly important in focusing us on what we are seeking to achieve. But certainly the way the Act is currently framed, consistent with its history, we may say it's an outdated history, but a history nonetheless, is that those objectives are sought to be achieved through the lens and through the prism of competition. And for that purpose, we have imported into our Act the best economics learning as it existed at the time of this Act in order to achieve those outcomes. Because competition law is not insensitive to issues of transformation. It's not insensitive to issues of equality. It's not insensitive either to issues of growth or innovation. There is, in traditional competition law, I would suggest, a very well-developed set of norms and standards, both legal and economic, that tries to balance these competing objectives. On the one hand, to grow the pie, and on the other hand, to grow the participation in the pie. The question, I suppose, that we are debating, without perhaps necessarily saying it, is what happens where traditional notions of competition don't get you to the objectives that you are seeking to achieve. Now, we all know when this Act was first developed and when the amendments to the Act were being suggested, the idea was, well, let's keep can I call it a classic competition act, because we then know what we're dealing with. And to the extent that there are other imperatives to get to constitutional outcomes, you use other acts to do that. You don't try and stretch the concept of competition law beyond that which it is able to do in order to achieve objectives and imperatives that are not those consistent with the law and economics of competition. The decision was made, rightly or wrongly, I happen to think rightly, to try and incorporate both of these different streams into the Competition Act. But I think it is important to realize that constitutional interpretation only goes so far. What one I think has to be very careful of is, in one's ambition to try and achieve an outcome, denude the notion of competition and competition law of any significance, because then we should have a Transformation Act, frankly, and we should say what we are seeking to achieve are the outcomes in the preamble. Let's scratch a line through all the traditional notions of competition law and have a Transformation Act, and then we wouldn't have this tension anymore. And that is a choice which is available. But my personal view is, at the moment we have a Competition Act. It has made various provisions much looser in order to accommodate objectives not otherwise achieved by the classic notions of competition law. But there is still a competition law test in our Act, and that can't be disregarded. And the danger is when you say, I'm going to interpret this particular provision with an outcome in mind. In other words, I ask the question, just for the sake of example, does this promote transformation? If it doesn't, well, then it is anti-competitive, because that would denude the competition test of any significance whatsoever. Then you might as well conflate exclusion and anti-competitive effect. And that is a fundamental distinction that has animated our Act for over 20 years. It still animates whatever the developments in other countries, the competition laws of those particular jurisdictions as well. And if we are to be that radical, and of course that is a choice we can make, I think we need to be intellectually honest that that's what we're doing. And with it, to be aware that once we make that important conflation, we are sacrificing many of the benefits of the traditional competition test. And that is something we should be doing with open eyes if that's the path we're going down.
Thanks, Jerome. I will swing right back for your rejoinder. But in doing so, I want to ask you a direct question. Jerome is saying the effects test is going to be perverted in essence. And I'm wondering from you, and in response to some of what Jerome is saying, are you seeing a new frontier for the effects test? We had consumer harm, we've got foreclosure. What is this? What is the new era, the transformative, the purposive version of this look like in your eyes?
Thanks. Just to say that it's trivializing the debate with respect to say that what we're looking for is a Transformation Act, just as a start. And I'll answer the question you asked. We're not saying do away with, let's take anti-competitive effects as a test. We're not saying do away with anti-competitive effects. The point, and that's what the Constitution requires, is if in the application of that test under the Act, you're going to implicate a Bill of Rights, you must be sensitive to adopting an approach which promotes rights. You're not doing away with, otherwise you say do away with company law and just say you want transformation law. You can trivialize everything because the Constitution informs the interpretation of every act that has a potential to impact rights. And the preamble provides the context. The question of effects arises in this context. So the question that is posed is, what happens when the act doesn't deliver the goods that you wish to attain? There may be two reasons for it. It may be that the act doesn't provide sufficient mechanisms for you to achieve the outcome which is consistent with the purposes of the Competition Act. That might call for an amendment. For instance, if it makes it difficult to give effect, to effectively implement the abuse provisions, but there is a way in which you can amend the provision to make it possible for those provisions to be effectively implemented. You can amend the statute, if that is the source of the problem. But you could have a second source of the problem, which is you have a perfect statute, but it is distorted in the implementation. The implementation undermines the achievement of the purposes that it sets out. Let me give you one practical example. In the second Jalu judgment, which was the case where banks decided to unbank a group of companies. And those groups of companies participate in various markets other than the banking market. And you have a complaint about interim relief about refusal to supply scarce goods. And let's accept for present purposes that the banks are individually dominant and the banking services are scarce goods. And all you are concerned with is what is the, you're thinking about harm. What is the harm, the competition harm that may be suffered? Now, the approach of the tribunal was to say you could have a vertical harm in which you exclude the banks in their, the companies in the markets in which they participate, and ask itself, how substantial would such an effect be? And say, well, you can't conduct any meaningful commercial activity without access to banking facilities. And it's clear that all banks will not bank this group of companies. They have looked at all tiers of bank and they will not bank it. Third-party payment systems will increase costs, plus their customers are not happy with third-party payment systems, so they will lose custom as a result. So you're either going to end up with exit or lessened effectiveness in the markets in which they participate. That's the tribunal, and it says you could have that effect, and it's important to the tribunal that these are small and medium enterprises owned by previously disadvantaged individuals. They look at all of that, barriers to entry, everything, and say there is, at a prima facie level, a case for harm. And the CAG comes along and says, there is no theory of harm that the tribunal posits. Because if you're going to find a anti-competitive effect of a vertical nature, the banks must have an interest in the markets in which the companies that are unbanked participate. In other words, there must be some form of leveraging of market power in the downstream market. Now, this refusal to supply relates to the amended section 8.1d Roman 2. Previously, that provision said, prohibited a refusal to supply a rival, a competitor. And so the theory of harm in those instances would involve leveraging of market power, because either you're raising rivals' costs and to dampen their ability to compete. And it says, but you can't have the theory here. That's the KEC speaking. You can't have the theory of harm here because there's no allegation that the banks have any interest in the markets in which the companies operate. Nor is there an explanation why the banks would want to achieve an anti-competitive outcome in those markets. That's the theory of harm. And so there is no prima facie case. The KEC doesn't even go on to look at the balancing act in terms of 49C, looking at the other factors. It simply says you fail at the threshold. Now, there are a number of problems with that framework. The first is the theory of harm, of course, can be met because it's not applicable to a customer. And this was the case brought when the section was amended to include a prohibition against refusal to supply in the case of a competitor or customer. And the reason you take on customer is because you have in mind a customer who is not a rival. Because if the customer is a rival, it's already catered for in the existing provision. But if you adopt the theory of harm, of course, no customer who is not a rival will ever will never discharge a competition harm test for purposes of that section. So you make that section ineffective by sheer application, as if theories of harm are immutable, but actually they must serve the act and the purposes of the act. The second point is asking about why would the banks want to achieve an anti-competitive effect downstream or in the markets in which these firms operate, is asking for motive or intention. Already, Media 24, in the context of predatory pricing, has said that you can't tag on intention to total costs as a measure of costs in order to found a contravention of the predatory pricing provision. And it says, importantly, intention is irrelevant because intention is incongruent with Section 8. Section 8 is about effects. What's the KEC doing asking about motive and intention? The third point is it accepts that there could be a vertical foreclosure, but wants the tribunal to go down into the individual markets to identify what the actual impacts are on the firms that are excluded by consequence of the refusal to supply. Now that, in my mind, goes against the jurisprudence in CompuTicket, in SAA, which tells you that on foreclosure, you're not looking to prove SLC. When you think about substantiality under foreclosure, you're only thinking about the substantiality or significance of the Foreclosure Act. And here, it's likely to completely exclude. How less substantial can it be? But now you're asking us to go down and show, in a sense, without saying so, we must show SLC. That too denudes the provision. So it doesn't help to suggest that, well, this transformative approach is moving away from traditional competition. Is that even when you amend to advance the purposes of competition law as expressed in the Competition Act, in the implementation, all of those can be frustrated by adopting stringent tests which are difficult for small and medium enterprises to meet. Which small and medium enterprise is likely to meet an SLC in a market in which it operates? It's likely to be not big enough. Its presence there is likely to be unimportant because it doesn't constrain other competitors. So its exit may make no difference to the structure of competition in that market. So basically, you're just making those provisions that you've amended to introduce for good reason ineffective. And that, I think, is one of the points that Baki was making about he had a better phraseology here. He says, the jurisprudence don't match the policy choices. And that is a matter of application, interpretation and application by the courts. And this, I think, is, you asked about what will be the new frontier. I suspect that depending on the nature of the court, you could have a clawback on the Mediclinic approach on this argument that the Constitution has no business in competition law, because competition law is about efficiency and competitiveness of markets, and that's it. That the goods that we promised under Section 2, in fact, help deliver rights, is lost. And that is the disjuncture in the criticism. Thank you.
Thank you, Nwako. I mean, Jerome, your point about exclusion equaling effects, I'm starting to see in a whole new light in view of what you've just said about small to medium firms and perhaps their insubstantiality to the market as a whole. As you said, Bake did speak to where the judiciary perhaps is even perverting the legislative intent. And what we recall is that we're not dealing with an act that's a flowing river here. There's always the text. And so in response to one of your points, Jerome, about should this just become the Transformation Act, I think it can't, because the text still provides for competition tests. But in interpreting the texts, we have a three-pronged approach. There's the text we look to, there's the context, and there's the purpose. Bake, I'm curious about a direct example where you think that the judiciary has perverted the legislative intent.
Yeah, thanks, Mpumi. I think the clearest, I won't call it perversion. I'll rather use a more benign formulation and say it's more of a diffusion of the legislative policy choice. I think the clearest example of that is the INJ case of the Competition Appeal Court. Within the context where the Competition Act clearly makes a distinction between per se contraventions as well as rule of reason contraventions in 4.1a. What we then see happening in INJ is that under the guise of a contextual interpretation, by the way, that contextual interpretation was said to be located in the Constitution. So under the guise of contextual interpretation, in terms of which interpretation is said to be a process involving the triad of text, context, and purpose of a statute. We see there an interpretation of market division in a manner that, of course, context, I do agree, context is important. But what we see here is contextualization away from the text, as if the text of the statute, as if the text of the statute is subordinate to the context. Whereas in the interpretation exercise, there ought to be an equilibrium between the text, the context, as well as the purpose. There has to be an equilibrium because the text is not inferior to the context in as much as the context is important. But what we see there is is an emphasis on the context of the statute in a manner that creates tension between the text as well as the context. So I think it is clear that what is needed is a renewed emphasis on a unitary interpretation of the Act that combines All the three. By the way, Jerome has just said that the purpose is not part of the act. It is. I accept that the context is also part of the act, but so is the text. So when the commission draws the court's attention to the text, it is then accused of literalism, or a literal interpretation, but that is not necessarily the case. The context has to be congruent with the text in the process of juridical interpretation. Otherwise, the jurisprudence then produces these outcomes that are completely out of kilter with the text. And remember, the text is the only way in which the legislative policy choice has been expressed. Yes, I think INJ will be a good example of that. But within the abuse context, the Uniplate judgment of the CAC is another example of this diffusion of the legislative policy choice. Because there, what we see in keeping, I mean, it's all consistent because it's goalpost shifting in the form of elevation of the threshold. What we see there in Uniplate is the court saying that foreclosure of a competitor is not sufficient to activate the threshold of anti-competitive effect. What must in fact be demonstrated is that that foreclosure of a competitor has a broader market distorting effect. So you can see a subtle elevation of the threshold with the result that there is then this goalpost shifting. When all that the abuse framework references is the proof of an anti-competitive effect. So we see in these cases this goalpost shifting, and it is quite worrisome. Another example will be within the context of public procurement, the bid rigging cases, where you see a very weird test being introduced in bid rigging that in order to activate the bid rigging provisions, parties to the bid rigging must have had a history of being in a competitive relationship. That I would say qualifies to be labeled a perversion, because what it does is actually to enable bid rigging, because as we know, within the context of public procurement, most of these firms are set up sometimes only for purposes of that bid, and you will not have a history of a prior competitive relationship prior to bidding. So in a sense, we have a jurisprudence that enables collusive tendering in public procurement, with the consequences for public procurement which are too ghastly to contemplate. So these jurisprudential outcomes that we are seeing are, I think, clearly worrisome. I think there is a need to retrace our steps and to reframe the trajectory of this jurisprudence going forward in this post-COVID scenario that, or the post-Mediclinic world that we are in. But the jurisprudential outcomes, I think, are quite worrisome. Hence, then the emphasis that you see post-Mediclinic on the invocation of the Constitution to try to mediate, and in fact to bring sense to what is happening by way of jurisprudential outcomes that we are seeing. Thank you. Thank you.
Thank you, Bake. Before I get to the audience, I just want to ask you, Andre, are you seeing such similar ideological tensions in Russia? I mean, I understand that there are amendments that are happening in response to, as you said, economic context. What is your experience there?
Yes, thank you. It seems to me that it's a very interesting problem that we are discussing now, because the text of the law, the purpose of the law, the spirit of the law, and the interpretation of the law are in so complex interconnection that it's, I think we couldn't find the final decision even with this brilliant company of experts. But talking about the legislation, yes, any legal act is a compromise. Any legal act is a choice. It's a choice of legislators, but not only of the legislators, of course, but by the people of the country, finally. And I remember 1991, when we passed our first law on competition through Russian parliament. It was the end of Soviet Union. It's a destruction of economic interrelationships. And when we present this law in parliament, there are some voices. Yes, there is 5 days stock of bread in Moscow. And you try to introduce this strange thing as competition into our life. But finally, the consensus was found, and the law was adopted by this parliament with very complex party organization and it was different interests of different groups of parliamentaries. 2 years later, the fair market competition became a constitutional value because it was directly introduced in constitution, in new constitution of Russia in 1993, and it's defended and promoted by the constitution, by the text of constitution. After that, we have 5 packages of legal changes, of amendment to Russian competition law, and the final 5th package of amendments to Russian competition law enforced on the 1st of September this year. So it's quite new one. What is it about? It is a law of digital nature, and amendments to this law are directed to settle some problems that exist on digital markets, first of all. It doesn't mean that without these amendments we couldn't do something with the digital companies inside Russia and abroad, because in the list of our clients during last 5 or 7 years, Google, Apple, Booking.com, Microsoft, and so on and so forth, Facebook, all big international companies, as well as Russian big digital companies. But it seems to me that now it's time to put some provisions that don't change the spirit of the law and the basic principles of competition legislation in Russia, but that will help in the future to deal with these big international digital companies. The law introduced some new definitions, like definition of digital platform, definition of algorithm, definition of network effect, and introduce some quantitative and qualitative thresholds and definitions when and what circumstances the digital platform can dominate the relevant market. New thresholds for M&As. For instance, the volume of transaction. Yes, it's very popular in different countries of the world, and it aimed to catch and leave under the anti-monopoly control the transactions with uncalculated assets, yes, with the intangible assets, and it's very important change in our law. Moreover, there are some procedural changes in our legislation. For instance, the right of the parts of transaction to submit conditions, sort of conditions to competition law that could be included into the final decision on this transaction. The expansion of the Institute of Independent Expertise in Competition Law Enforcement in cases of violation of competition law, in analyzing of transactions, and that is very important in control over implementation of the decision made by competition authorities. So we introduced the popular in some jurisdiction mechanism of trustees. It's important, first of all, for very complex cases of violation of competition law, especially in digital markets, when without the special knowledge in some areas of knowledge, it's impossible to control over the implementation of our decision, and the decision making itself is very difficult to make. But it takes us more than 5 years from the first draft of this law to the final decision of the Parliament. 5 years of very intensive discussion with a set of stakeholders, with parliamentaries, with other bodies of executive power of Russia, with business representatives, with IT companies itself, with providers of telephone and communication, and so on and so forth. 5 years, but finally, the decision has been made. It is consensual. It is a decision of all parties that are represented in the Parliament of the Russian Federation, because it was 100% vote for this law, finally.
Yeah, we are not the only ones who are responding to market realities using amendments. So I'm throwing it out to the audience to see if there are any questions. I see 1, 2, 3 hands. Audience went up first. Thank you.
Thanks very much, Mpumi, and thank you for the great discussion. My question is to Hilton regarding the example of Sekunjalu, and specifically regarding the criticism of the CAC in relation to the tribunal, who stopped basically after the exclusionary conduct analysis and not taking it forward. If I understand correctly, in that matter, Sekunjalu did not even bring the market shares of the different firms operating in their markets. And that made it very difficult for the tribunal to even go to the point of doing any kind of effects analysis. And that was the critique of the CAC. In SAL, everybody knows that that firm is massive, and therefore you can extrapolate that something like exclusion and foreclosure will quite likely have a very anti-competitive effect. But if the client doesn't even bring its own market shares, and the tribunal don't ask for it, or I don't know what happened there, because it's not in the decision at least, then there's nothing that you can do. And then it is indeed a case where the analysis stopped prematurely. market shares could have even helped with making a decision regarding participation. So that was my understanding from some of the issues regarding the harm. It was not just the issue regarding foreclosure that has been misinterpreted. And we must remember the tribunal has lately been found wanting for stopping analysis halfway. And there's a couple of examples. I don't want to go in there now. Let's give people the opportunity, but this is indeed a serious problem that the tribunal do not complete the analysis. Thanks.
Yes.
Okay. Yeah. Thanks. You're quite right that the CAC criticized the tribunal's analysis of effects, and as I said, that it didn't drill down to the individual markets and see what the impact would be of exclusion on competition in those markets. You're right on that. My commentary was not on the analysis of facts and whether the analysis comes out correctly by the tribunal or by the competition appeal court, is looking forward in the context of our discussion about standards, whether the lens through which the CAC gets to its conclusion is the correct framework for the amended section, which, as I understand, expands protection beyond mere rivals. And therefore, one can't look at assessing effects in that context by asking for a theory of harm which involves leveraging of market power by the dominant firm that would generally be vertically integrated and present in the downstream market. So it is the framework that I'm criticizing. The question of whether there was sufficiency of evidence may be a matter that's, if the case goes on appeal, may be a matter that's debated before the appeal court. When the matter served before the tribunal, it was dealing with all of the banks, but the CAC was only dealing with the 3 banks that appealed the decision. Others didn't appeal the decision. In respect of the remaining firms, there were in instances where Sekunjalo had to dispose of the firm because it couldn't carry on conducting business in the market because of no access to banking facilities. So there was evidence of that kind, and evidence about costs for procuring third-party payment systems, and the fact that customers were not happy with those third-party payment systems and would not carry on supporting those firms. I accept that there would be a lot of debate about whether the case in fact turns on the legal framework and the application of the framework or simply on the assessment of facts. But the criticism I'm making is, given that with the exclusion of the SCA from hearing appeals from the Competition Appeal Court, to a large extent, the Competition Appeal Court is the final arbiter on competition matters, and it is only very few select matters which the Constitutional Court will be happy to take, because every time you have an application to the Constitutional Court, the respondents throw the book at the Commission and the court and say, this is all about facts, and intimidate the court from even being appetized to consider taking the matter and hearing argument. And so the framework which the CAC has set out, let alone the analysis on the facts and where it comes out, that framework remains part of our law. Now when you come before the Competition Tribunal and you're involved in a foreclosure case like this, which does involve a vertically integrated firm which is leveraging market power, respondents will say, well, the CAC has spoken on this. There is no prima facie case. And also as to the standard of what a prima facie case will be, the way in which the CAC approaches the application of Section 49C, which really asks of the tribunal and to grant interim relief if it is reasonable and just to do so. So you have a value judgment up front, considering a number of factors. Prima facie case, harm, and balance of convenience. What the CAC does, departing from e-media, where it embraced Mediclinic, departing from e-media, I accept that e-media was a vertically integrated firm, so there was leveraging. That's different from here, I accept that. But the departure from e-media is you don't look at all of the three considerations and do a balancing act. If you fail at the threshold, which is the prima facie case, you're out of the door. Now, if that is what is going to be the framework for assessing interim relief, this case, bad as it might be on the facts, it creates bad law. And it is in the context that even when you have amendments, you could have outcomes of this kind. It is not necessary. It wasn't necessary for the CAC to introduce a leveraging of market power test. If, as you say, even on the facts, you can, on accepting that there could be a foreclosure effect, which doesn't involve leveraging of market power, there is no case, or there's no dominance, or there's no coordination on the prohibited practice. You don't have to restate the law to damage the law, reverse the gains in the law, if the outcome turns on the facts. And the problem we have is that when, at the time, it sounded to many that the SCA was conservative and it's better to take it out of the picture. But what you're left with is effectively a final decision by the CAC. And just recall that the CAC is not constituted as an expert court like the tribunal is. The tribunal has economists on the panel. So when they debate these issues around theories of harm and what likely effects and all of that, there is economic expertise. The CAC is drawn from the High Court. So you might have the current president who has the background from sitting on the tribunal, sitting with two High Court judges who've never been exposed to competition law, but deciding a competition case and reversing expert assessment by the tribunal. And that is where the Constitutional Court in Mediclinic said, you must appreciate the expertise of the tribunal. You must only interfere if there is a material misdirection by the tribunal or they are clearly wrong in the application of economic principles. But in my experience, the CAC tends to reevaluate matters as if it was sitting as the tribunal. In this case, what it says is we're not changing anything the tribunal did. What we're saying is it adopted a framework but didn't follow through. But actually, they do say there was no theory of harm when in fact the tribunal formulates the theory of harm, which I would think is the more appropriate one because it's not based on leveraging of market power, which is not appropriate for a customer foreclosure. Thank you.
Karabo is ominously standing by, and I want to check, can I take 2 more questions? Okay, and you've got one online. So Jerome wanted to come in. I've got 2 more hands coming up. In the meantime, can we get Lara a mic while Jerome responds to Udi's question?
Thank you, I'm back on. I don't want to get stuck on the second Jali facts because I know that matter happens to be going back to the tribunal in the next week for our argument, but I have taken advance notice of Hamilton's submissions on all of that. But let's abstract from those particular facts and just ask this question because I think it goes to the heart of the debate we were having earlier. Assume you have a bank or a number of banks that decide to unbank a particular HDP firm. And let's assume for the sake of the argument that as a result that firm will not be able to do business in the market anymore. It is an HDP firm. And those are the facts. There is nothing more. Let's assume it has a 1% market share in the market in which it participates. Now, the traditional competition law would say, tick on exclusion, cross on anti-competitive effects. It makes no difference whatsoever to competition in the market whether that firm is there or not there. The question is, do we accept that outcome? And we say, well, it's not anti-competitive, sorry for you, you can't get relief under the Competition Act. You might go somewhere else to get from a banking regulator or the like, but you can't do it under the Competition Act. Or do you say, no, that defeats the preamble of the Competition Act. It defeats the ultimate purposes sought to be achieved in Section 2. So we will read anti-competitive effect in a constitutionally compliant manner, effectively read it out of existence, because we will now conflate exclusion and anti-competitive effect, and we will say the exclusion of an HDP firm is anti-competitive in the context of our economy, because that's what we are seeking to achieve. And I think that is a very good example of the debate that is circulating around the Competition Act at the moment. This is not particular to South Africa. We know in the UK, Mr. Farage was unbanked by Coutts Bank because of his unattractive views that he expressed about the European Union and the like, and he was taken to task, and they had to rebank him. But that wasn't under the competition legislation. That was under the laws applicable to banks and what their duties are to clients. The question is, in the context of South Africa, do we expand the Competition Act to regulate and to achieve what we regard as adequate outcomes in that context? Or do we say, I'm sorry, competition law can only stretch so far, it doesn't address that issue, you must either amend this act or go elsewhere in order to get relief? And I think that is the big debate.
That's not what we're saying, and that's not the debate. We accept that you will look for effect. We are saying we are using a wrong framework in the criticism of the CAC. So it's not, nobody has ever suggested, and the Constitutional Court didn't suggest that as long as you've excluded an HDI, you've breached the Competition Act. That's not, that's wrong. But you do understand your effects analysis through the lens of the Constitution. It doesn't mean that the mere exclusion, it might feature when you're thinking about substantiality. If you think about the Mediclinic scenario, you had uninsured patients who on a post-merger would be faced with a double-digit price increase in the merged entity, when prior to the merger, they could receive cheaper discounts, better discounts from the target firms, and there was a Life Encron close by in Krugersdorp, and there was evidence that patients, uninsured patients, shop around for better prices. But the consequence of the price increase in the target firms post-merger would lessen the incentive for the Life Encron to give discounts and preclude the ability of uninsured patients to have choice and to bargain in the way that they did. And the question revolved around whether that is substantial lessening of competition. And what the merging parties told us was only 200 people in that market will be affected by this. Through a constitutional lens, the exclusion of one person to access to medical health care in the context where you have rising medical costs is substantial. That's the lens. So it must be understood. We're not saying scratch out the Competition Act. We're saying the Competition Act itself tells you, interpret me through the lens of the Competition Act and interpret me in the manner that achieves the purposes of the Act. You're not throwing away the text and all the history learned from America and the EU. We are simply saying in this country, our Constitution says we can make legislation, and in that legislation, we can adopt particular policies, provided they are not inconsistent with the Constitution, they remain binding. So let's not trivialize the debate by giving us extreme examples when what we are talking about is close to the center and not the extremes.
Thank you. So I think the best way to get through questions is to go question, 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 and then we'll come back to the panel. So Lara, you are up next.
Thanks, Mpumi. I suppose both Jerome and Wako have gone some way already now to address my question, but maybe it's more of a comment at this point or an issue for Wako to consider, is the concern of throwing the baby out with the bathwater. So I don't think that there's anything inherently unconstitutional with a consumer welfare standard or anything inherently unconstitutional with an effects test. It certainly comes through in the application of it. And these kinds of standards were put in place in a constitutional era within the Competition Act. So, and it's still about achieving competition, because what serves the Bill of Rights and individual rights better than considering at the end of the day how are consumers placed, how are consumers able to access goods, how are consumers able to live and benefit from the conduct of entities. And that might include giving further opportunities to small and medium enterprises for the purposes of achieving dynamic competition, dynamic efficiencies in the long term, and a more open economy, also again with the view on the objective of competition and serving consumers at the end of the day. So when I say don't throw the baby out with the bathwater, I suppose that's addressed primarily then to BICA, to you know, not for the Commission to view the consumer welfare standard and the effects standard still within the constitutional framework. They aren't opposed to the constitutional framework.
The gentleman in the middle had his hand up. If we can get him a mic while we listen to the question online.
I hope I do this question justice. So it reads, if we don't have a gap in our consideration of anti-competitive effects for the other abuse provisions that are not specific to SMMEs and HDPs, for example, predation or inducement, do you think that the remaining standard is sufficient to address SMME, as it typically requires one to show a market-wide impact as opposed to a firm impact? I hope that was clear.
That was clear. Thank you.
you.
Let's take the other question, and then we'll come back to the panel.
Thank you. My question has been answered partly, but it's directed to Advocate Manager. So I just want to know, with reference to the Mediclinic judgment, in advancing our inspirational goals of the Constitution and those of the Competition Act, does it mean that all measures automatically implicate the Constitution? If the answer is yes to that, particularly because if I look into the judgment in itself, the Constitutional Court does little in explaining the jurisdiction in respect of competition matters. Obviously bearing in mind that it's usually a specialized area of law, you know, and usually they are decided on factual disputes that are usually involved. And then you find a situation where the Court has said it assumes jurisdiction, although the matter had been, one, a factual dispute of fact, and secondly, most of the legal principles in the situation were actually settled legal principles. So does it have any impact in our competition law regime? Thank you.
Thank you. All right, one last bite at the cherry to respond to Lara on Segunjalo. Okay, I hear there's one more hand. Okay, yes, Mokhal.
Is it my
That's
turn?
you.
Okay.
You have the floor.
All right, thank you. So, some of the issues I had have been dealt with very nicely by Advocate Manager and Bake. I just have few fundamental issues I need to raise. One, so you have a majority of people in South Africa poor. They are blacks, they are poor, they don't have money. You have minority that are white, wealthy, lots of money. So even now when you walk out of this venue, you'll see black people walking along the street. You hardly see a white person walking along the street. So now, we are debating issues around transformation, around deconcentration of the economy. And I hear Jerome saying that, you know, when you go to you look at the traditional notions of competition law, you know, whatever we're trying to do, we should not lose that, those traditional notions. It's also making mention of the fact that the pie is not, we've got to grow the pie so that we can increase perhaps inclusion, participation, or even transformation. But how do we grow the pie when those that have money doesn't want to invest or doesn't want to grow the pie? That's the first thing that I would want you to deal with. And secondly, so do you think, in your view, if people were as rich as white people, black people, were as rich as white people, would we be having a problem of growing the pie in South Africa? So or is it perhaps the issue of our forebearers making a fundamental mistake of resolving or transitioning us into democracy without demanding economic compensation? So that when we get there, we got here, we all have money. We are not poor. So, because it's not, this thing of economic transformation, it's not happening. We are just talking every year. You go back home, you are hungry. You're sitting here, we're talking good English, but we don't actually have anything. We are poor. Yet there are people who are rich, nothing is happening, they continue to be rich. And when we debating these issues, trying to say how best can we deal with them, there are always these technical issues of, say, when you are dealing with competition, maintain the notion of competition law. Don't bring too much issues of public interest. Secondly, the other issue, controversial as it is, I'm gonna raise it. So in my view, I think the judiciary in this competition, and I want your reflection to the extent possible, all of you. Judiciary in the space, in the field of competition law, they are legislating. They are changing the law with the judgments. The judgments that they issue, and we have all touched into it, you are just not saying it the way I'm saying it. The judgments that they issue, especially judgments on cartels, they are all not in line with the law, the text of the law. There's a characterization, and then with the characterization, then the judgment goes against what the law sought to prohibit. So, and I'm saying that this, you see, they are taking over the function of legislature, the function of parliament. They are another arm of our government, state. So they are legislating so that they don't live to the spirit of the act. They are undermining the legislation. The legislature represents the will of people. So if the people elect and the legislature put laws and the court changes the law, I want to hear from you, what is that? The advocates that are sitting in front of us, that are implementing, interpreting the laws, when things go like this, what should then happen ultimately? Should we accept that the law will just be changed by courts when the legislature is clear, or what? This is not sustainable. That we have a clear law. Advocate manager says depending with the court. So it's basically saying it depends with who is in the court. The law might be interpreted in a particular way. That particular way, whether it's within the spirit of the act itself or not, it gets to stand. But is that sustainable for South Africa? I just want us to really talk about the real issues that are facing the country, in particular are facing the majority of the people who are black people. Thank you.
Okay, if we can go perhaps down the line, because there were questions to each of you, and we can start. Bake, are you ready? You can speak to the question around Section 8 generally, and whether the legal standards in Section 8 as currently applied are sufficient, or whether there's further amendment required, even though we're looking outside of just the HDP and SME prima facie change that has been imposed.
Thank you, Pumi. I think the amendments, the 2018 amendments to the abuse of dominance provisions, as well as the price discrimination provisions, are quite progressive. Because what those amendments do is that they have resolved some of these challenges that Jerome was talking about, in the sense that they have introduced, and this is quite creative, they have introduced public interest protections for SMMEs and HDP-owned firms against abuse of monopoly power. So I think that is quite progressive, because this recognition of socially or economically vulnerable classes, I think it's quite progressive. In fact, in the US, there is also a recognition of protected groups. So this is something that is quite consistent with what is also happening elsewhere. Same as in the price discrimination provisions, you see special protections for SMMEs as well as HDP-owned firms. And it is clear that this is in recognition of the fact that if one were to apply this broader market distortion framework, and Jerome is quite right, if you apply that test of broader market distortion, then these firms would be insignificant in that analysis. Yet these firms have a place in the economy. And we know that the structure of the economy that we have, it's a dual structure. In the sense that you have the first economy, well-developed, technologically advanced, but you also have the second economy, which is more informal, and there's a disconnect between the two economies. So it's an economy where if you are an outsider, Mahali is quite correct, you are an outsider. If you are an insider, you are an insider. There isn't an interaction between the formal as well as the informal economy. So if your test for exclusion is going to reference impact of market distortion within that bifurcated economic framework, then you are not going to pick up this exclusion of the smaller firms. And the outcome will be that you essentially reinforce the bifurcation of the economy that we see. So I think the amendments are indeed quite progressive insofar as there has been a recognition of this vulnerability insofar as SMMEs and HDP firms are concerned. I think in the future there will be a need for the extension of the same public interest framework to areas such as excessive pricing. And not only abuse of monopoly power, but even exploitative, even exclusion, both exploitative as well as exclusionary abuses. I think in the future, there will be a need for that. But of course, the protection in relation to monopoly power was aimed really at securing the place of SMMEs and HDP firms as suppliers. Because the intention is to ensure that there is this supplier base of SMMEs as well as HDP firms, which, by the way, it's an audit of the South African economy, because in other economies you have we have a very strong supplier base in the informal sector. But the audit of our economy is that that supplier base in the informal sector is very weak, and it is not able to challenge the more established supplier base in the formal sector. So we have to correct that audit, and the amendments are a step in the right direction.
Absolutely.
In terms of trying to address that distortion. So there is a clear link to competition, but through a public interest analytical framework.
Thank you. And I think what the question also asks us to consider is, what do we do about those firms that are not HDPs and not SMEs for whom the presumption does not exist, and the old interpretations of Section 8 are going to prevail over understanding the conduct in relation to those firms. Moving on to Jerome.
Yes, is there another question for me, or am I adding on to Bake's response?
And you can respond.
Yes. Well, let me do that, because I think both the question and Bake's answer raise, for me, still a central limitation in Section 8 of the Act. And the question is, how ambitious is competition law going to be? Because if it's going to be truly ambitious, it would effectively reflect an approach throughout the abuse of dominance provisions, and frankly, perhaps even in Section 4 and Section 5 of the Act, which is not limited to, can I call it, classical notions of anti-competitive harm as being one of the necessary elements. Because we know that in terms of the amendments, the notion of exclusion has been expanded, and I think very importantly and significantly, for reasons Bakhali indicates, to include participation in the economy. But there is no anti-competitive, there's no prohibited practice of exclusion per se in our Act. Exclusion is still, in terms of the statute and our case law, only one element. It's a qualifying element for channeling an inquiry into anti-competitive effects. If you are happy as a legislature with a world where you still need to demonstrate anti-competitive effects, well then I think the Act is fit for purpose. If on the other hand you say, looking at the state of the economy, looking at the lack of transformation that has taken place in the many years since apartheid came to an end, something more radical needs to be done for all the reasons Bakhali indicates, well then currently the Competition Act I don't think achieves that. And the big question then is this the Act through which that more radical transformation agenda should take place, in which case you are going to rid yourself of any meaningful distinction between exclusion and anti-competitive effects, or are you going to try and achieve those objectives elsewhere? And I think that again is one of the frontier questions that all competition practitioners and the regulators are wrestling with at the moment. But ultimately, because at the end of the day, we are all in different ways creatures of this statute, we need to interpret it as best we can through the constitutional lens that Nwako mentions. The question is, does that go far enough? At some point, are you interpreting so significantly that effectively you are trying to achieve an outcomes-based result without going through that lens of a competition analysis?
Thank you, Jerome. Nwako, final comments?
One question about the jurisdiction of the Constitutional Court and whether it impacts competition. I think there was a question there. So prior to the amendments excluding the SCA, the Constitutional Court would only assume jurisdiction if there was a constitutional issue raised. But after the SCA was taken out in respect of the Competition Appeal Court and the Labor Appeal Court, they expanded the jurisdiction of the Constitutional Court to include a legal issue of public importance. So for instance, in the Mediclinic case, the jurisdiction was assumed by the court on two bases. One, there was a constitutional issue, and also there was an issue of the proper interpretation of Section 12A, which the court regarded as a matter of public importance because it would affect future cases, and it was a point which had some prospects of success. So, but it's still a very limited, if the case turns purely on facts, they will not assume jurisdiction. It's only if there's a constitutional issue or there's a legal issue. Otherwise, the CAC is the final decision maker if cases turn on facts. And always, when you try to access the court, if you're the complainant or the commission, having lost at the CAC, the strategy is to put up facts and say, this is all about facts. And sometimes rightly, sometimes as a matter of legal strategy. And then they'll say, sorry, it doesn't engage the jurisdiction of the court. Yes. That's the end of it.
Now, I'm acting under strict instruction to end this panel, and we are already over time, unfortunately. I want to thank you as well, Andre. I'm so sorry I can't give you final remarks. But to our panel generally, if we can just give them a round of applause for their excellent submissions today on legal standards.
Thank you very much to Mpumi and her panelists. I did say when this session was about to start, what I expected fire, and I guess fire we got. We are running slightly late, but the session was very important, and I think the entire team felt it was important that we do take questions from the floor. We are wrapping up. I'm about to call the DC, Hadin Ratisusu, who's going to give the closing remarks. As you come up, DC, I just have a few points that I'd like to make over issues that have been raised over the last 2 days. DC, yesterday we heard issues around SMMEs struggling to survive in the South African economy. I am not surprised, DC, just based on the previous session as well, where we heard that these SMMEs are literally feeding off the crumbs of those minority that are running the economy or that own the economy. We are at an economic hub, as the commissioner said on day one. If you had taken a walk around, you would have seen that the SMMEs that are around here are black youth, black young people. So these are the people that, when we talk about transformation, these are the people that are desperate, Commissioner, for us to get transformation right. We spoke about issues of load shedding and the negative impact that it has on business and the economy in general. Commissioner, I drove from the Free State and drove past Cecilburg, the town, one night. There was load shedding. As I drove through from the corner, the one side was extremely dark, and there was Cecil, bright. The township was dark. Cecil looked like it was New York City. And these are black people that are living in these status. Commissioner Kanye yesterday, when they were talking about the section on energy, spoke about the fact that there is a request, or the government has actually implemented a reduction on the economic development elements in terms of the REIPP programs. This essentially says that if companies want to come and invest invest energy or get projects in energy products in the country, all they need to do is set aside 10% only that needs to be allocated to economic development. By economic development, those elements essentially include ownership, they include transformation, they include skills transfer and enterprise development, only 10%. Commissioner, yesterday we also heard about the importance of supporting women in business. We spoke about equity and the issues, the gender-based barriers that women face. Commissioner, the other day I heard on radio, I was listening to an interview of a researcher who said that he conducted research. It was a sample of men, black and white. And when he did, he analyzed their motor vehicle funding contracts. And what he found was that black people are paying 10% more on their car loans than white people are. And he confirmed that his study was confirmed by an actuary. Commissioner, you can imagine if women are facing gender-based specific barriers. Imagine being a black woman trying to do business in South Africa. Lastly, Commissioner, we spoke about the high prices of food. I made a comment to James and Wandile as they got off here to say that it is the black people of this economy, of this country, that are struggling to afford food. We cannot afford to have high prices of maize and poultry because that is the staple of our people. And I don't know that there's anyone in Sandton who's actually worried about the prices of food, but I know people in a village called Makwat in the Free State that are scrapping and scrambling. DC, as you close, I hope that those sentiments come out. There's a group of people, the majority of South African people who are black, who are looking and waiting for us as the competition authorities to achieve this transformation. They cannot afford for us to say we are still trying and we are still talking. They are waiting for us to act. DC, with those words, I allow you to come into your closing remarks.
Thank you very much, Karabo and Ufense. I think you did a splendid job. And it feels like we've just started. But as they say, good things do come to an end. And I think I got a sense that there'll be a lot of learning here and unlearning. And it seems this has been achieved. Commissioner Doris Tsepe and Competition Tribunal Chairperson Mondo Mazwai, you were good hosts. Even though you had a cold, I think that really requires an applause. I think you did deliver your remarks under difficult circumstances. I was supposed to do this for 15 minutes, but I've been assigned to do something in 10 minutes. It's happening now. I have to cut this. I know there are a lot of guests, and it's very important. You have traveled far. We really have to acknowledge all of you, starting, of course, with the Minister of Trade and Industry. He has never missed this conference, I think, since 2009. We really appreciate that. We had the Competition Appeal Court Judge President Norman Manoim. We do have acting deputy commissioners from the commission, deputy chairperson of the tribunal. I cannot see him here, but he was here. We had members of the tribunal.
Le camera le swak nyana nje akubonakala ngale siblisi into yakhona light so by
So, and on Wednesday, we hosted BRICS, heads of authorities. So we did have representatives of the heads and their representatives. So we had deputy head of the AFS Russia, Andrei Tsiganov. You saw him here. We had Victor Fernandez from CADE, Brazil. He was here with us. We had the chairperson of the CCI in India, Ms. Ravnin Kau, she was here. There was a representatives of Vice Minister Gan Lin, who joined us virtually, but her representatives were here from Beijing. Secretariat of the AFCFTA, our DDG, Tanya Van Mielis, we really appreciate this, that you are able to sit here with us for all the 2 days. We had heads of competition authorities. From the Gambia, Amadou Sisi was here. The head of Mauritius Competition Authority, Deshmukh Kolesa, was here. Representatives of the competition authorities of the USA, you have seen them from the DOJ and FTC. Botswana. Perfect. Okay, thank you very much, Karabo. I think that matter has been resolved. The matter has been resolved. So, and we had representatives from Botswana, Kenya, and COMESA. Why do we go through this list? It's really us appreciating the time colleagues take. South Africa is a bit far, you know, from a lot of places. So when you take a trip down here, we do really appreciate it. We had delegates from COSATU, they spent time here. We had senior advocates. I did not mind them continuing because I don't think we can afford that kind of advice. So thank you very much. Don't expect invoices for this. So we had legal practitioners, academics from leading institutions. Jonathan has been there like a student from VETS. He's kept that seat to himself. We had BRICS Competition Law and Policy Center representative. The director is still here, which says a lot about the conference and how engaged we are in this. And we have to observe all protocol because this is a difficult thing that I've been asked to do. So if we have not acknowledged you, we have. We have acknowledged you. So this, as you know, was the 17th annual conference. I've already mentioned the activities we had before. there was a dialogue on Wednesday, jointly hosted by the USFTC, ourselves, and the DOJ. As the BRICS meeting happened here of the heads, and we will be in New Delhi soon for the BRICS conference. The ACF met here, and we will be in a month's time, hosted by the Gambia on for this conference. I will not repeat, I think, what the speakers have said. I don't think it's my job. But you have heard, I think the speech of the minister is quite clear and points to the need to deepen regulatory measures to address market concentration issues we have for economic inclusion. And that's a message to the competition authorities. You probably want to know how many of us were here. We had 447 registered guests, over 100 joined, they streamed on YouTube. The good thing with the streaming is that if you missed any of the sessions, that material is available. I visited myself. I think we had a discussion sometimes on characterization. To prepare, I went through a particular session that discussed that particular issue. Discussions were rich. I think, Karabo, you summarized a bit, but for those that may have missed some, we started with the competition policy protocol, looked at rising food inflation, role of major control in addressing market concentration, advocacy showcase on study of women, business energy markets, competition priorities in the path to NHI, and the last session on appropriate legal standards. And let me not try say anything about what has been said in the interest of time. So I will move straight to, so it's not to suggest that we do not recognize all the keynotes. I think it's just really about time. I hope you appreciate that. So on behalf of the Competition Commission of South Africa, the Tribunal, and by extension, the Department of Trade and Industry and Competition, we want to express our heartfelt gratitude to our program directors, quite able, all the speakers, panelists, moderators, and attendees who have made this conference a resounding success. But Commissioner Tsepe, there's one thing that if we do not do, we will be in deep trouble, and it's going to be a long thing. It will be quite remiss not to acknowledge the important role played by our conference organizing team members. So we had a committee, commission, and a tribunal. So you had Hari Prasad Govinda, is over there, Itebuheng Palare, Jabulan Ngoveni, I'm sure they are still here, Nandi Mukwena, Precious Mathive, Sipongwema, and Zugile Sokopase. This great team has also been supported by a collective of great individuals. Again, we have to try. So if I miss anyone, please forgive us, please. Abraham Tiro, you saw him moving with the roving mic. Brenda Maseko, Dinah Suawedi, Enika Pizzo, Lydia Mulife, Moranye Pala, Noktula Mushweu, Nontlatla Kunene, Ponalo Tinishe, Regina Manzini, Tukelo Makwala, Dolanis Kosana, and Sanelen Zimande. And of course, sincere thanks to our communications, finance, and logistics team. So you have been moving around with shuttles, some of our staff members, for making this possible. Again, this list is not exhaustive. We also thank our service providers. So the guys who streamed the event, the photographers, the venue host, and everybody who supported us in this process. You have all done a sterling job. So organizing a conference of this magnitude is no child's play. Can we please give them a round of applause, please? So to the venue, I think we did enjoy the venue. I know there may have been doubts when we all came to Riversands, but once you're inside, it's amazing. It's beautiful. So I think we are where we are supposed to be. So thank you very much. And there's one thing that perhaps we should say. As you know, next year we turn 25 as the Competition Authorities of South Africa. So we will be celebrating this 25th anniversary. So you are all invited. Everyone who stayed here, who is here now in this room, is invited. So you will get the front row seats. We assure you that one, there'll be high demand. So we will guarantee, your seats are guaranteed right over there. And for everyone who'll be traveling, please travel safe to your destinations. Those that are staying over for the weekend, do enjoy Gauteng province, or if you're going to other provinces, please do enjoy. We hope you enjoyed this part of the city of Johannesburg. The street name you used just changed when you came. I don't know whether you had anything to do with that, but the street name just changed as the guests were coming. So if you had Googled the place William Nicol, that street no longer exists. So it's Winnie Mandela Drive, so this is where we are. Until we meet again, colleagues, please do join us for the cocktail outside. As far as the summation and what we think of what was being said, I think this was quite clear. I don't think it needs anyone to add anything. If you really want to revisit this, as I said, it's available on the stream. We are usually, as usual, open to engagement, but I think there are a lot of issues that are being raised that I think we'll have to take forward. We won't wait for the next conference. I think there are important issues that we need to engage on, and we will do so, and that is the purpose of this conference. It is a very important platform to reflect as the Commission. If you felt like you criticized us somewhere, it doesn't affect us. In fact, we appreciate it. I liked it when Council were talking about Sekunjalo, because it's interesting that it's a case that it is yet to be, we are yet to finalize the investigation. It's still at interim relief. So all of this is about interim relief. So hopefully, whatever is done, when that interim relief is considered, that does clarify the issues for the Commission to be able to finalize the matter. So thank you very much, and I hand you back to you.
We are not going to waste any more time. I think I enjoyed the audience. I think so. They were just minor little things that we should fix for next year before they come to the celebration.
I'm not sure that James shares the same sentiments, because when you said you enjoyed them, he started scratching his head. So I'm not quite sure we're quite on the same level. But ladies and gentlemen, thank you very much. You've been an amazing audience. And because you've been an amazing audience, cocktail is now 15 minutes and not 10 minutes anymore.
Ladies and gentlemen, once again, my name is Karabo Motaung Mushala. Ki ngwana wa Mosotho, ki ngwetsi ya Bapedi. It's been an honor. Thank you.